Good morning, everybody. Happy Monday. Welcome to TCF Live. My name is Dan Soul. I will be your guide through Courtlandia for the next 4 or so hours. Let's get started in Michigan. This is the 44th District Court. This is Magistrate William Urich.
But it is considered serious enough that the officer issued the citation on the date in question. You will be required to make a selection from one of 3 options, and 3 options only to protect your rights today. You may, if you wish, simply admit responsibility. The court will attach a fine between 0 and the maximum, and that'll close the case. You may also, if you wish, admit responsibility, but with an explanation that you believe mitigates your circumstances. Your 3rd option is to deny responsibility. That is absolutely your right. If you do so, the court will conduct your trial forthwith. The officer will be sworn, as you will be, and the officer will testify first. It's their burden of proof. Then it is your turn to testify. Then the court makes a finding of responsible or not responsible. But please remember, since we are in civil court, the burden of proof on the people is a mere preponderance of the evidence characterized as the featherweight test. So it is not a heavy burden of guilt beyond a reasonable doubt. With that said, if you have a documentary case involving plates or insurance and you have fixed that circumstance, please have that document handy, as that might expedite your case. So the court will return you back to the waiting room and we'll bring you back one at a time. Thank you. Court calls case number 26 RO 01350. This is People versus Jennifer Marie Cook. That's you. Ms. Cook, you'll need to unmute yourself. That's fine. Ms. Cook, you were present earlier when the court explained the informal hearing process. True?
True.
And so you understood the court's instruction that you must select from one of 3 options to protect your rights, correct?
Correct.
Thank you, Ms. Cook. The citation before the court was issued by Officer Patron on March 10 this year at about 8:15 in the evening. You were operating a 2024 Chevrolet Colorado, gray in color, southbound Main Street, entering Willis Avenue in the city of Royal Oak. At that place and time, it was discovered your vehicle plate had expired on your birthday right around last Halloween. So this is simply an expired plates, non-moving 0-point violation. You can admit responsibility. You may admit and explain, or you can deny responsibility, and the court will conduct your trial. Ms. Cook, what do you wish the court to do?
I would like to admit and explain.
Very well. So you're confirming with the court that on the date in question, your vehicle plate was in fact expired, correct?
Correct.
And that vehicle was being operated by you in the city of Royal Oak.
Yes,
Thank you. You have a registration?
I do. I don't.
Try
I
to
don't-
hold that closer to your device. Oh boy, you got your filter on.
Oh, will that help if I turn it off?
It would certainly help if you turn it off. Oh, you've done this before. Thank you. Officer Patron,
I'd like to make a motion to dismiss, Your Honor.
motion to dismiss. You don't have a problem with that, do you, Ms. Cook?
I do not.
All right, happy birthday. You know what to do next time.
I do. Thank you very much. Do I need to do anything now?
You don't need to do anything else. Just drive safely and have a good summer.
Wonderful. Thank you very much. Have a good day.
You too. On case number 26 RO 01352. This is People of the City of Royal Oak versus Brett Michael Shornack. That's you.
Yes, correct. Good morning.
Shornack, you were present just a moment ago when the court explained the informal hearing process. True?
Yes,
So you understood the court to instruct that you must select from one of 3 options to protect your rights. Yes?
yes, sir.
Mr. Shornack, the citation before the court was issued March 10 this year at about 7 minutes of 9 in the evening. You were operating a 2019 Chevrolet black and color on 11 Mile Road, right near Washington Avenue, City of Royal Oak. At that place and time, it was discovered your vehicle plate had expired last April the 19th. So this is a 0-point non-moving citation for expired plates. You may admit responsibility. You can admit, explain, and display an updated registration, or you can deny responsibility. The court will swear the parties and conduct your trial. Mr. Shornack, what do you wish the court to do?
I am admitting the responsibility, and I do have the updated renewal here.
Thank you. So you're confirming to this court that on the date in question, you were operating a motor vehicle in the city of Royal Oak with an expired tag.
Yes, Your Honor.
Okay. May the court have a look at that registration?
Yeah, absolutely. Let me flip my camera here.
Can you bring that in a little closer and say your name again?
Yes, Brett Shornack. This is the transaction receipt for the updated vehicle renewal.
Officer Patron.
I'd like to make a motion to dismiss.
Motion to dismiss, Mr. Shornack. Whatever anniversary that April 19th is, it'll keep coming around. So thank you for getting your business done. Good luck to you. Take care.
Thank you. Appreciate it.
Good morning once again, everybody. TCF Live on a Monday. My name is Dan. It's good to have you all here with me this morning. Slow start for a Monday out in Courtlandia. We will continue to monitor and switch around as other courts come online, but for now, we'll continue with the magistrate.
Raymer?
Yes.
Ms. Kramer, you were present earlier when the court explained the nature of an informal hearing. True?
Yes.
So you understood the court's instruction that you must select from one of three options to protect your rights, yes?
Yes.
Ms. Kramer, the citation before the court was issued January 16 this year at about 7 minutes of 8 in the evening. You were operating a 2009 Mercury gray in color on Main Street at or near 11 Mile Road, City of Royal Oak. And at that place and time, it was discovered your vehicle plate had expired on February 4th of last year. And at that precise moment, you were unable to produce a physical proof of insurance for Officer Patron. So these are two 0-point non-moving violations of expired tag and no proof of insurance. You may admit responsibility. You can admit and explain or deny responsibility, and the court will conduct your trial. What do you wish the court to do, Ms. Kramer?
I can admit and explain. I do have photo evidence that I've amended the error since.
Okay,
the,
so on the date in question, you were operating a motor vehicle in the city of Royal Oak with an expired tag, and at that point, you were unable to produce a paper proof of insurance, correct?
Yes.
Okay, do you have those documents right now?
I do have photos of me holding them. I'm not sure if you wanted me to hold them up to the camera or not. I was just told I
That would
needed-
be fine if the officer is satisfied that you've taken care of the business. That's really what counts.
Okay, perfect. If you'd be so kind as to allow me to share my screen,
Hey, go ahead.
I'll show you. Do I have permission to do that? I apologize. It's been a minute since I've done Zoom.
I think it's wide open. I don't believe the court needs to do anything. I think you're ready to go once you can facilitate it on your end.
Oh gosh, and I was warned not to have technical issues. I apologize.
You were doing fine.
Would you be so kind if I grab the actual papers and return with
That
the
would be fine.
papers?
Take your time.
Okay. Thank you very much. One moment, please.
No worries.
All right. Well, he's waiting for that defendant to come back. Let's head over to Judge Anzalone. She is doing our front of the court hearings.
Sharp. Oh, we have another minute, but file number 2007-31555DS, that matter has been dismissed. Michael McAnally, you might come up to the podium. In the matter of Shalisa McAnally versus Michael McAnally, file number 2013-39382DM. Mr. McAnally is present in person. This is the date and time set for show cause. Okay, so monthly charge of $230. At the original show cause, his arrearage was $9,389. Back in February 24. Today it's $11,972. But Mr. McAnally did turn in his paperwork from Cooper Bender from Workers' Comp on September. Are you working?
Not yet, but I do have an appointment next week with my disability doctor. That's the next step to finalizing the disability. And then I do have an interview with Glove Industries.
Yep, Glove Industries.
Yes, yep, I have an interview with them next week too. So
Okay,
hopefully that'll work out. Really-
okay.
Really hoping that'll work out.
So next week, you get Glove.
Yes, sir.
Okay. And any progress on the matter with Cooper and Bender?
That's the doctor's appointment next week. Yes, ma'am.
Okay, so,
And then I do have a $50 payment I can make today.
okay, all right, so, go make that and bring the receipt back up for me, all right, thank you. In the matter of Rebecca Krutz versus Aaron Krutz, file number 2018-45207 DM, Aaron Krutz. This is the date and time set for show cause. Mr. Krutz was ordered to appear. Mr. Krutz is ordered to pay $525 a month in child support. We were last here for a show cause with the arrearage at $11,522. It's gone up $1,050. Last payment we had was $293.56 back on January 31 of 2025. Do we know if he turned the paperwork in for review or?
I don't see any notes indicating that. Yeah, we also haven't got anything well, payment wise at all from employer or cash payment.
Okay, so I'm gonna issue a bench warrant for failure to appear and I'm gonna set bond in the amount of $3,000. Mr. Madrid, want to come on up? All right, this is in the matter of Abigail Craig versus Michael Madrid. Mr. Madrid is present in person. File number 2020-47630. Let's see, Mr. Madrid, you're ordered to pay $342 a month. Your arrearage as of today's date is $17,093. We did get $2,500 back on March 5 of 2026. Is that your income taxes?
No, that was when I bonded out.
Okay, okay. All right, you're supposed to pay $400 a month for March and April.
I did have that today, but I tried to do it online last night and it said that I already had an account and.
How much did you pay?
Today, right now I got 372, but I have to go to the ATM and get the rest out of the 800. She told me to go do it, but I said, no, I got court at 8.
Okay, who told you to go do it downstairs?
Yeah, the lady downstairs.
Yeah, so go ahead and do that and
Yeah.
bring your receipt back after you pay the full amount, all right?
All right, right now?
Yeah.
All right, cool.
Thank you. So, Mr. Anderson, in the matter of Catherine Brink versus Michael Lewis, file number 2009-34541 DP, he showed up last week. Mr. Lewis did.
Yeah, I do remember that. And we gave him this week's date, so I'm not sure.
So, he usually shows up
Yeah,
a little bit late, so we'll hold off on him.
okay.
And we're just waiting for, what are you here for?
For Todd Crock,
It's next door.
and they sent me over here to you.
I know. Yeah. I'm sorry, it's Judge Olsaver.
Okay, thank you.
Thank you.
All right, well, she's in a delay. Let's go ahead and move on. Let's go to where justice is best served in a converted pole barn. Otsego, Michigan, Judge Mertz.
Appearances on.
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor.
James Dick on behalf of Mr. Trevor, who's standing to my right, Your Honor.
Thank you. Mr. Dick, can you tell me where things stand with this file today from your standpoint?
Yes, Your Honor. So I received a stipulated bond order this morning from the AG's office. And because a third party posted the bond in this matter, I'm waiting on that person to sign he signed the document and get it back to me. I did speak to them this morning. It is sitting in their email. They did agree to sign off on it. So at the present moment, because I just received that, I will ask the court for a very brief adjournment, perhaps. I think the gentleman that I spoke to this morning said he would sign it today. So if we have even a few days, that would be sufficient.
Okay, and is that part of a plea agreement?
Yes, and so my apologies. So the plea agreement, my understanding would be a delayed sentence where Mr. Trevor would end up pleading guilty to one count of failure to pay child support. And he would be put on that delay for up to 12 months at the court's discretion, of course. And then if he were to pay it off in full, Mr. Green, is it all right if I proceed with that, or do you want to put the plea offer that would be available on the record?
I'd rather put it on the record because my understanding is a bit different than yours.
Okay.
I think at the end of the day, it ends up the same, but the offer was that we would give Mr. Trevor a delay of sentence. That's what we would offer. If he could pay his arrearage down to $20,000. So the bond, I think, is $3,500. And if he paid that, if he could transfer that over, it would get him to that $20,000, but he wouldn't be there yet. And I think maybe that's something that we can work on. That wasn't the previous offer. I think we might be able to get him the delay if he transfers. And what we were asking was that he plead guilty to the 4 counts for the delay. And then if he could pay down to $12,000, what we would do is allow him to plead guilty to 1 count of attempt, and we would dismiss the other 3. And of course, if he pays in full, that would be 1 count of disorderly, it's a misdemeanor disorderly conduct. So, but there was a $350 payment that was made, and we weren't sure if that was a 10% surety bond that was being moved, or if the $3,500 hasn't been moved yet. It appears that the $3,500 hasn't been moved. So the offer I'd like to make today is that if he would move the bond over and apply it to the friend of the court, then we would offer the delay of sentence in return for him to pleading as charged.
Okay, and you're indicating that the bond, that's what you want to work on is
Yes.
moving that bond. Okay.
Yes, Your Honor.
So what I'd like to do then is give council an opportunity to make that happen. And then Mr. Trevor, I think based on what was said here, give you another opportunity to speak with Mr. Dick about the plea agreement, because it sounds like it is a little bit different than what you may have discussed with your attorney. So my next date will be the full motion day, beginning of May. So I'll reset this for a hearing on that date. And then, so that'll be about 2 weeks. So Mr. Dick, I think that would be enough time based on what you're saying today.
Yes, sir.
Okay. So Mr. Green, the court's going to reset this for a plea hearing at the beginning of May. I don't have an exact date or time for you today, but the court will send out notice of that. Whether it's you or a different AG, you're free to appear by video for that hearing. Mr. Green, anything further that we need to address today?
Only one thing, Your Honor, in the past few months, the defendant has either failed to pay at all or paid much less than he owes for his ongoing monthly obligation. And I think it's important for him to show good faith and pay as ordered each month in full and on time, or it's really difficult for us to foresee a future when he's going to be able to agree to the terms of a delay and pay then. So he hasn't been paying and he needs to start doing that.
Okay, all right. Mr. Dick, maybe you can talk to your client about that.
Yes, sir.
Is there anything I can say? I mean, like I got,
There is, he has contacted front of the court to work on reassessment.
yeah, like, I mean, let's say like I got a check paid Friday, and I'm self-employed for a business. And I literally just made a payment to the front of the court at 8:30 this morning. And I mean, I'm literally trying my best. Like I've been
Well,
trying to keep
Your Honor,
calm.
Your Honor, the current obligation is $1,055 per month, $1,055. And I understand if the defendant wants to go to the underlying court and try to get that reduced, but currently that is the order and that's what he's obligated to pay.
Understood.
Okay. All right, thank you. That's all for this hearing today. We'll be back in about 2 weeks.
Okay, thank you, Your Honor. Appreciate it.
Thank you, Your Honor. Have a good morning.
Once again, everybody, good morning. Happy Monday to you. My name is Dan, and welcome to TCF Live. Let's stay in Michigan, but we will go to Judge Elmore. Say good morning to him.
Here on the record this morning now for the 28th Circuit Court here in Westwood County, and we begin today's docket call by taking up the case of People of the State of Michigan versus Devin Jean Plum. This is file number 25-14153 FH. Appearances, please.
Please sit down for the people.
I'm Jeff Harris, I'm here on behalf of Devin Jean Plum. She's joined me at the table and is here in person.
Thank you. Also present before the court this morning is Mr. Brian Potter, who is the probation officer, who has prepared today's pre-sentence investigation report. We're here today for a sentencing on a case that we resolved with a plea back on January 23rd of this year. The first thing we're going to need to know is obviously we're going to change the sentence date on CFJ 145 page 1, and that's throughout wherever else is required. See if I had any other corrections. Make sure we've got the information correct in the CFJ 284 regarding treatment history. That would be on page 15. So we know that there was that program that she's been in. When did she enter that, Mr. Harrison?
It was February
Like
17th, it was
yeah.
just before her birthday, I remember that.
Yeah, I remember 17th. All right, so, and that was where, Ms. Plum?
Sunrise. Alpena.
There is a paragraph there, yeah.
Oh.
Oh, okay, well, yeah, and I see that at the
Yeah,
bottom,
that's right.
but I want to know, did she complete the inpatient portion?
She did.
So we wanted, that's why.
Yes,
yeah.
sir.
All right, good enough. And what's the status with the sober living facility, Mr. Harrison?
At
Or
this,
Ms. Plum?
at this juncture, she's done what I would say was the next best thing. Sober living is not gonna be available to her until at least May 1st. It had something to do with her NMRE status.
Uh-huh.
In light of that, she's gotten a housing voucher
Yeah, remember.
and a job and is enrolled in an outpatient program through the Sunrise Center and Treatment Center where Gaylord.
No, it's Bear River and it's intensive outpatient.
Yeah.
Yeah,
What
and
did
well,
I
I'm
say?
enrolled in Gaylord in Bear River
I
treatment.
got it, thank you. So
Sorry.
if there's, then it is, we don't need to, just note that she's doing the outpatient therapy through Bear River.
We have a completion date of Sunrise, Your Honor.
Yeah, it is the 27th of March.
Thank you. Thank you, man. All right, have there been, are you on any other medications as a result of that? Like a Vivitrol or some kind of other?
I'm on the Sublocade shot. I did send information to community corrections. I'm also on Prozac, which I wanted to make that a point because it does make me drop for benzos.
All right, so hold on. So we see on CFJ 284, page 15 again. Underneath that public health drug abuse, it already has an MAT Subutex. Is that the same thing though?
It's the Sublocade's the shot, the Subutex is the pill.
The pill, all right,
But I didn't want the like temptation of
I got you.
using it.
So that's why I'm mentioning that the Sublocade, we probably want to put that on there as well. Now, you also mentioned that the is it Prozac?
Mhm.
Okay, and that, oh, that's already on there. All right, thank you very much. Okay, so I don't have any further corrections. Let's turn it over to the prosecutor, Ms. Dahl. Do you have any corrections, objections, so forth?
I believe there should be an addition for employment after the case,
Oh,
even
yeah,
she
yeah.
started.
Yep, sorry, thank you very much.
Thank you.
Where's this, I know you told me last week, but I don't recall.
It's KFC and Gaylord.
Okay,
It's a full-time employment too.
what's that?
Start date, Your Honor.
It's about 3 weeks ago. I'm not sure the exact date. I could look on my phone.
April 1.
Yeah, I'd say.
That's fine. Okay,
Thank you, Your Honor.
yep. All right.
No other corrections or deletions, Your Honor.
Mr. Harrison.
I don't have any changes. I did note the 3 or 4 that were brought up by other folks, but I don't have anything beyond that. In all honesty, I had forgotten about updating the employment, so I'm glad Mrs. Bell pointed that out.
All right. By the way, my brain is full of stupid information. Dave Thomas, who started Kentucky Fried Chicken, actually didn't start it, became famous for it. He used to work for Wendy's. And then when he was working, he met the colonel and said, you got too many items on your menu, and he went to go work for him, trim the menu down. That's why Dave Thomas is really famous. But anyways, there you go. And by the way, it wasn't really a colonel, he was a Kentucky colonel, which is nothing to do with the military. All right, let's just keep going. There you go. That, by the way, is free. Don't have that. I'm not gonna pay for it. Mr. Harrison, elocution.
Well, Your Honor, it's no secret that I'm exceptionally proud of Devin. And that's the only, I thought about a way to say that sounded a little less avuncular, but.
What?
Avuncular in the manner of being someone's uncle or older relative.
Yeah, did you look that one up over the weekend and then
No.
think, you know, how can I work that in?
No, I,
By the way, you kind of look a little bit like
Colonel
Colonel
Sanders.
today. You got the hair.
Yeah.
he was tiny though.
Yeah.
I've got
They
no,
had one of
I-
his suits on display in a museum in Kentucky,
Uh-huh.
and the man was literally this big.
But anyways, just keep going.
No, I don't know what else to say that hasn't already been presented to the court in some fashion. We have a young woman who had a serious issue with her involvement with controlled substances. There were some lifestyle factors and some psychological stuff going on there that, to no one's surprise, she had a difficult time disengaging herself from that. I hesitate to reuse the word, but I'll say it again, that lifestyle. And lo and behold, the current situation that we're here to talk about today is part and parcel of why it was almost impossible for her to break that cycle on her own.
Hold on. So it's working up there, but my computer isn't working. Oh, just
We're
working.
still on there, yeah.
All right, just, it says reboot required for system updates. Disregard, I'll hit that and say, remind me later. All right, keep going, Mr. Harrison.
Yeah.
You got it, I'm paying it, I've got it, we're paying attention.
If you had a sort of vision about what you would like a person in her situation to do, I think if you made a checklist, here's what I would want her to do in a perfect world. She's ticked off nearly all of the boxes. And the one box she hasn't been able to tick off is sober living, but she's done what she can to ensure that that will be something she will partake in just a couple of weeks. If everything goes according to plan. Now, normally, I guess on the case where the client is 2 to 17 and the recommendation is for time served, I would say a lot less than normal. I was gonna say I would probably say nothing, but I don't believe that's ever been the case. But in this case, I think it behooves us to, quite frankly, keep the pressure on Devin. I don't think it's necessary. I don't think it's going to be the thing that pushes her over the edge, but I think it's something that she will always take away in the back of her mind, how grateful she is to even have this opportunity. It's pretty telling to me that she's had a couple of opportunities here to shirk certain responsibilities or to frankly not throw her dice in and fully cooperate. And I'm very encouraged by the fact that she has been able to make the right decision and do the right thing, not to panic when sober living wasn't immediately available. She doubled down, went back to them and said, I've got to have something more than a promise of sober living in a few weeks. And that's what she's doing right now. She has the letters of completion and all of the glowing remarks from people that, quite frankly, the drug counselors, unless they're very, very, very good at their job and did an in-depth job, they may not even appreciate the depth of her situation when she was presented to them. She has all of the markings of being a success story, an example for this community and for people similarly situated. And she's young enough to pull it off. And she has an excellent story to tell. And I hope someday she gets the opportunity to tell it in a way that can help other people. Because if anyone would have had the opportunity to walk down that tunnel and not see the light at the end of it, it would have been her. To her credit, she has been able to focus on eyes on the prize and has enough impressed me with her ability to do that. Her familiarity with her own situation, her self-awareness that was something that was lacking in the past. So I'm glad to see that that has developed. I can't say enough good things, but I guess having said so, I will conclude my remarks unless I beat the dead horse any further. I agree with the recommendation, time served. I agree. The only reason I would want her on a period of probation is so that there's some structure and there's somebody looking over her shoulder. And I think it's important to give her the opportunity to prove to herself that she can do it, not just us. She's on her way. She's well on her way. I'd like to keep her on that track. Thank you.
So, Ms. Dahl, although Mr. Harris, you talked about not kicking the dead horse, he had a couple more in there, but that's okay. Ms. Dahl?
Your Honor, looking at Ms. Holmes' prior history, it is odd to recommend.
Hold on. We're gonna take a brief pause right there on the record there. Nancy, hold on. We have lost our wait for program. Nope, we're gonna close it. We are in recess in place, there, Nancy.
Alrighty, the Monday has gotten Judge Elmore. Technical difficulties there. It happens. Stay in Michigan. We'll go say good morning to Judge Prill.
File number 257342FH. It's time and date set for sentencing. The defendant is present, represented by attorney Kyle T. O'Mara. People are represented by Craig Pappin, Pappin, Assistant Attorney General. The court notes that the defendant previously pled guilty to failing to pay child support. That plea was entered on January 26th of this year. Ms. Karen Everly has prepared the pre-sentence report dated March 2nd, 2026. Court is also in receipt of another document. This is a 3-page document dated April 17th, 2026, entitled Michigan Child Support Enforcement System NCP Financial Detail Report regarding Mr. Sherrard. Mr. O'Mara, did you provide the court this copy?
I did, Your Honor.
And does Mr. Pappin also have a copy?
I believe so. I provided it to Ms. Messer, who I think passed it along from the Attorney General's office, so I believe passed it on to Mr. Pappin.
That is correct, Your Honor.
All right. All right, and are we proceeding to sentencing then?
Yes, Your Honor. Just by way of update, the document you referenced was provided to establish that Mr. Sherrard has paid the full balance of his arrearage. On March
2000.
Yes, Your Honor. On March 30th, he paid the final payment of $22,766.52. I confirmed with the front of the court on Friday. He does have a zero balance on that arrearage. I passed that information along to Mr. Pappin's office. I think has been confirmed on their end as well. And I discussed this with Ms. Everly last week. So, Your Honor, because the offer was structured in such a way to give Mr. Sherrard the period of the delay of sentence in order to pay the arrearage and earn a reduction to a disorderly person non-support misdemeanor, I believe that the parties would stipulate to that conviction entering now and then proceed with sentencing on the misdemeanor. But obviously there's no need for a delay anymore because the arrearage has been paid. But I asked the court to confirm that with Mr. Pappin.
Mr. Pappin, what say you, sir?
Well, Your Honor, I think that is the effect that the original offer was, that if he were to pay in full, we would amend the charge to disorderly person. He has fulfilled that obligation. I think the proper procedure is he withdraws his plea to the felony non-support, re-enters a plea to disorderly person. We have no objection to move forward with sentencing on the disorderly person today, Your Honor.
Any objection to proceeding in that fashion?
No, Your Honor.
All right. So let me place Mr. Sherrard under oath. Would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Mr. Mayor, do you wish to question me, or do you wish the court to? I can, Your Honor, if you prefer, whatever you prefer, giving you the opportunity. Thank you. Mr. Sherrod, you understand the offer that had been tendered by the people previously, which you pled guilty to, whereby the intention was for you to be placed on a delay of sentence for a period of 11 months, with requirement that during that delay, you pay the arrearage that you owe in this support case in full. Understand that? Yes. And now you can confirm to the court that you have paid that arrearage in full. You borrowed the money to do so. Do you have any objection to the court withdrawing your plea to the felony offense, entering, I believe, just take a judicial notice of the previous plea, correct? Entering the guilty plea on your behalf to the misdemeanor non-support and then proceeding with sentencing now. Do you have any objection to that? No. And you're asking the court to do that? Thank you. Mr. Patton, do you have any questions of the defendant?
No, sir. I believe the original factual basis for the original felony charge would suffice for the disorderly person, which is just simply a person of sufficient ability who refuses or neglects to support his or her family is the basis or factual basis for the misdemeanor charge, which is punishable by up to 90 days and a $500 fine.
And I would agree. Court will allow the defendant and order the defendant's prior plea be withdrawn relative to the charge originally contained in the information subject to the plea offer. And as a result of that, the court will use that factual basis, so to speak, regarding disorderly person non-support. So what you understand is a 90-day misdemeanor carrying a maximum jail sentence of 90 days and or a fine of up to $500. You understand that? Yes. And you wish to have your plea changed to that? Yes. So ordered. My question is, what's crime victims' rights for a misdemeanor and statement of plea? I believe one is $50.
I would say probably the 50. Victims' rights fee. Trying to look it up, Your Honor, I'm not sure.
I might think it's about 50, but I don't know. $75. See. Okay. Objection to proceeding to sentencing. No, Your Honor.
No, Your Honor.
Thank you. Mr. Romero, what do you wish to say on behalf of your client before the court imposes a sentence?
Just, Your Honor, to his credit, I've handled a lot of these cases. Mr. Sharp is the first one to pay such a large balance in advance of disposition, in advance of sentencing. As I've indicated, he borrowed that money, obviously a pretty significant financial detriment to himself, but he acknowledges that he needed to make things right with his children and with the court. Mr. Sherrod is and has been gainfully employed. He's starting a business. To his credit, even prior to the court's involvement, I believe Mr. Sherrod was continuing to meet his monthly obligations, so the arrearage was not growing. But now he's borrowed money to pay that arrearage down to zero. So I asked the court to impose only fines and costs. As I've indicated, I don't see any reason for a probationary term or certainly any delay. I don't pass it as the court's practice to order any period of incarceration when defendants have paid their arrearage over the course of a delay. So again, I see no reason for the court to do so now when Mr. Sherrod has managed to make a significant payment in advance of sentencing. So I asked the court to impose only fines and costs.
Did your client wish to address the court?
I believe so, Your Honor.
Go ahead, sir. Sorry, I got behind on my payments. Trying to keep up with them safer. How you doing? How many children? It's tough, isn't it? It's raise 2 children. Okay. Mr. Patton, anything on behalf of the people, please?
Your Honor, the people would just request that it be 1 day jail, 1 day credit, minimal fines and costs.
All right, thank you. Well, Mr. Sherrard, in nearly 11 and a half years, I've never seen an individual come before the court and pay the entire arrearage off. I've never seen it. By credit, apparently, you took a loan out to take care of this. And I give you credit for doing so. Again, I've never seen anything like this before. And it goes to the idea here that, according to what your attorney said, bottom line is you have an obligation to your children. Here. Considering all that, then it will be the sentence of this court that the defendant pay a fine of $500, court cost of $200, crime victims' rights fee of $75, state minimum fee of $50. That all must be paid by June 15, 2026, or the 20% interest rate applies. Court will also order 1 day in the county jail, 1 day of credit, no probation, no community service. And there are no guidelines here because this is a 90-day misdemeanor. Is that really?
One question I have is attorney fees. Mr. Romero appointed or retained?
I was appointed. Your Honor, while you're looking, I'd ask the court to waive any attorney fees. Actually, the court is going to waive attorney fees under the circumstances here. I've issued the maximum fine and the court costs on top of that. So I'm waiving the attorney fees in this matter. But sir, don't get behind again. You dodged a felony. And that's significant. And I'm not saying dodge in a bad way. You took the bullet here, so to speak. But don't let this arrears go any further. Make sure you continue your monthly support. Good luck to you. My duty to inform the defendant he has right to seek leave to appeal if he's financially unable to provide counsel of his own choice. The court will assign counsel for him public expenses to initial receipt questionnaire form requesting the assignment of counsel, both of which must be executed under oath, filed with the court within 42 days. And this conviction then, Mr. Tappan, you can correct me if I'm wrong, either 750.167.
Yes, it is.
All right, thank you.
Okie dokie. Good morning once again, everybody. My name is Dan. Welcome to TCF Live. I've got a few things on this case that we just saw. First off, somebody please explain the logic to me of how you have somebody who is behind on child support. He took out a loan to pay off the child support. Good on him for doing that, I suppose. The judge admonishes him not to get behind on his child support, never, ever, ever again, and then proceeds to give him the maximum fine for that misdemeanor of $500 plus the court costs. That makes no sense to me. Don't do it again, but here's a maximum fine to make your financial situation just a little more difficult. I don't get it. So I'm currently working on a Substack piece, a couple of Substack pieces, honestly, but one of them revolves around this idea of how, especially in Michigan, we're seeing people plea to things that don't necessarily make a whole lot of sense. Like with traffic violations, one of the popular ones is allowing another to violate the vehicle code, even though the other you're allowing is yourself. That one never made sense to me. So it got my attention when they go from a felony support down to a disorderly person. I'm like, how exactly does that connect? Well, Michigan is odd. I looked it up. It does. MCL 750.167. A disorderly person is a person who is disorderly if it includes any of the following, and one of the things listed under this very broad code is a person of sufficient ability who refuses or neglects to support his or her family. That specific piece of MCL also covers prostitution, window peeping, public intoxication, causing disturbance, and vagrancy. So how the idea of failing to support your family fell under the exact same statute as prostitution, window peeping, and public intoxication, you got me. Pure Michigan, I suppose. Anyways, that's what the law says, so that one actually did apply. But I still don't get the concept of taking somebody who is struggling to pay their child support and hitting them with a max fine. You got me on that one. Let's go back to Judge Elmore. It looks like he's got his text issues solved and he can finish that hearing.
Figuratively bleeding, but Ms. Dahl, it's your turn.
Thank you, Your Honor. Her past is kind of concerning. She has 8 felonies, 10 misdemeanors. She has been to prison. She has violated probation multiple times.
She's got 120 PRB points, which is 45 over the max. Yeah, I got you.
So she has a very rough past, and her likelihood of successfully completing probation based on her past conduct is low, but she seems to be working hard so far, so I believe the recommendation is appropriate based on the guidelines. I believe 3 years probation is appropriate because of her past and where she's at right now, and I think it'll help hopefully motivate her and keep her going on the path that she's going. So I'd ask the court to follow the recommendation in this case.
Ms. Plum, you have the right to make a statement before the court issues a sentence. Is there anything you wish to say?
Yes, Your Honor. I just wanted to tell you, thank you for this opportunity. It's been very great, and I can only thank you and God for that. It's a very emotional thing for me because you obviously know of most my past and my family, so I'm not gonna, like, I don't have a ton of words, but I really thank you for this opportunity because I would have never got it anywhere else or at any other time, so.
So I'm going to go over a few things. Bear with me. I've got to be able to cover or justify the sentence. I'm going to highlight a few things. I remember, and we're not going to go into the factual debate of whether or not it's correct, but there was some assumptions or some statement somewhere in the process of this case that there was a recorded statement where you may have agreed to help those guys from Muskegon. Well, we kind of have an idea what that might mean. And I would say, listen, I really want to see you get away from that track. A delivery, for instance, or assisting in the delivery and stuff like that, Class B felony, and even at the lowest level of the guidelines would be 72 to 240 months.
Okay.
Right? That's 8 years of prison. And so that's I don't say that, but I'm just saying I'm going to assume, based upon the preponderance of the evidence, you were at that point where your life was going to go, whoop, and that's where you were going to go. I don't know. I would hope that you wouldn't, but that's just one thing. I'd hate to see that from a young person. If it were just a possession, which is how the case started, you would have scored 10 to 46 if there was the habitual offender enhancement or even the second or subsequent enhancement. That would have gotten a prison term. Sometimes prison is a positive, sometimes it's negative. I don't know, but I was afraid it would start that cycle of the revolving door for me. Yes, whenever I call a case, if I know the person's middle name, normally it's kind of it's a sign that I see the person too often. It's really easy or tempting, that's probably the better word, tempting, if not just natural, to start to pass judgment negatively, right? I've been over there, and now I'm up here. And sometimes it's when you pass judgment because you've seen a person's past behavior, you can almost place money on it and it'd be a pretty fair bet. But then sometimes, and I liken this back to my son used to really love, my oldest son, Thomas the Tank Engine. And it's like the trains, you sometimes you just want to, you know, I'm gonna put the train on the track and retrack it, and maybe relay out a different track and hope that the train stays on a different track. And I'm hoping that this is the time where instead of just rolling the train away, we've decided to put you on a different track, and hopefully that helps you. I really, really hope it does. I've got high hopes that it does for you. Again, I'm not gonna make anybody cry, but I know obviously what this substance has done in your family with your mother and your dad and so forth. And I'm hoping, just hoping that this is the time that you save your life and put it on the right path. You are still quite a young person. Oh my gosh, 33. That's young. All right, so I don't know, can't say it on the out loud here what your date of birth is, but I'm just going to tell you, I have my 33rd wedding anniversary next month. So I've been married longer than you, almost as long as you've been alive. All right, so now I got to cover the sentence to establish the reasonable proportionalness of the sentence.
And Your Honor, I do want to let you know that I've deleted my Facebook and all of my contacts in my phone.
Good. I'm going to tell you that there is a day coming soon, very, very soon, depends how tomorrow at 4 o'clock goes. I will get off of all of it as well. But anyways, or it will be greatly reduced down to my family, just my kids, my wife, my parents and stuff like that. But anyways, good thing for you. You know, there's a great deal of information here on CFJ 284, page 3, that talks about the amount of substances, 90.5 grams here and there, just horrendous stuff. I know maybe it wasn't all tied to you, but it just talks about the scene in which you were placing yourself. Your criminal history began in 2010, and right away you started having the probation violations. I started off with the retail fraud probation violations. You made it about 6 months before you picked up an operator while intoxicated, and there again, bench warrants, probation violations. You had a bond violation for 3 of 20, because that one occurred while you were on bond for the previous one, and yet once again, it involved MIPs and alcohol. You had probation violations again, 2011, that offense occurred on probation, more probation violations. 2011, there's another set of charges that came out. So we see a lot of probation violations, bond violations, repeat offenses, controlled substances, alcohol, things like that. Well, I'm not going to go through it because I don't want to be negative, but I'll just say, if there ever were an appeal on this case, any appellate judge or appellate attorney should just go and say, I've adopted all the factors incorporated herein that are inside this report. There's a lot of reasons this plum even to send you to jail or even give you prison now. But remain very hopeful. There's just something about it that I feel, I don't know. So I'm hoping it does. I really do. So, and thankfully you've been doing some of the right stuff. And he didn't come back. Because remember, there was something you mentioned last time. You didn't want to go back to your dad's house. Oh my gosh. Great choice. So anyways, the court's speaking positively, hoping the best for Miss Plum, places her on a period of probation for 36 months. I find that the terms and conditions listed on CFJ 145, page 2 and 3 are well suited for rehabilitative purposes. Specifically, any treatment programming, inpatient, outpatient treatment, making sure she's compliant with all of that, whatever she's, the medical assisted portion. Who is providing that medical assisted portion? Is that out of the Bear River Sunrise or?
Bear River.
All right.
Well, I got my first one in Sunrise,
Okay.
and then since I've recommunicated with the society, I do it at Bear River because that's the place in
The point,
Gaylord.
all right, so the point is, it just Mr. Potter needs to know because he needs to stay. keep doing whatever that provider is telling you to do. And I can't wait and look forward to seeing Ms. Plum come back to court for me to dismiss, let her off of probation early, if she's able to do so. You have the right to be considered for early discharge or probation at halftime, so that's in about 18 months. All right. The court sentences the defendant to 120 days, with 120 days of credit, $68 state minimum fee, $130 crime victims rate fund fee, $300 court cost, and the processing on this case, $300 attorney fee because, well, Mr. Harrison mostly earned his keep, $500 fine, supervision fees of $30 a month or $60 a month if there's any electronic monitoring. All right, have I missed anything, Mr. Potter?
Yeah, and I'm just questioning myself, not the court.
Okay.
The 36 months on a high court misdemeanor, that is a lot, correct?
Yeah, I think yes, because it's bumped up to a felony, isn't it?
I'm just.
I think so. I believe it as a high court misdemeanor. Yes. I can't go to the 60, but I can do the 36.
Okay. I just like I said, I was questioning myself here.
I got you. If you find them wrong, don't come and tell me because I don't want to feel bad about myself later on. No, I'm just kidding. That's everybody got it wrong, but I know. All right, Ms. Plum, I need to tell you that all fines and costs are due within 56 days, or a 20% penalty will automatically be added to it. This court, however, will dismiss that 20% penalty as long as you pay by the end of your probation. So if you decide, hey, I really want to get out from underneath Judge Elmore's thumb, after 18 months, you're going to want to pay it off before then. I'm really very hopeful, Ms. Plum. Seen you in there before. I've seen you when you've been under the influence a little bit. I'm telling you, the person that I see here today isn't the person that I've seen in the past. And I'm really, really very, very happy to see that. You look good, you look healthy. I mean, you know, so don't seem to have that look that I see on other people who come through who are using. So God bless you. Hope you continue to move well forward. All right. So Mr. Harris is going to bring you 2 copies of one document. You're going to place your initials on one. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of your copy of that document. And this document tells you that you have the right to appeal the conviction and sentence in your case. And while that is typically done by filing a claim of right to appeal if you were convicted at a trial, based upon a plea, any appeal is done by filing an application for leave to appeal. Now, if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of that document. I should have said, Madam Clerk, that the court exercises its discretion under the second or subsequent enhancement of sentence or as such. All right, Ms. Plum, on the CFJ 145 in this document, there are some end dates for the substances. October 22nd, 2025. That needs to be one of the most important days because that is the new birth date that you have. That changes your person. All right, best of luck. Any questions?
No, but I wanted you to know I have 6 months on the Friday we just had.
I'm glad. See you all next time.
Thank you, Your Honor.
Yes, ma'am. Our next file this morning is people.
Alrighty, friends, we can finally move out of Michigan. Other courts are starting to pop off around the country. Let's go to Florida though and do the Wade Mercer first appearances. There we go.
Because you've been accused of, good morning, you've been accused of one count of driving while license suspended or revoked, 3rd or subsequent violation. There's also an allegation that you have a current habitual classification also. So there is probable cause for the charge. Mr. Griffin, I looked at your criminal history, which is fairly lengthy, but I think you're entitled to a bond as far as I can tell. Let me listen to the attorneys and then I'll be glad to address your bond status. Mr. McDaniel, anything?
No, Your Honor.
Mr. Bell?
Your Honor, we would just ask for a reasonable bond and a condition of no driving whatsoever.
Mr. Griffin, I'm going to set your bond at $5,000 cash or surety. You do have a condition not to drive a motor vehicle. Now, if you do get your license back, obviously you can come back to court and we'll go through that. But you've got several things you would have to do to even think about getting your license back. But if you can do those things and get your license back, then we'll certainly consider that. But right now, no driving at all until the judge approves it. It's $5,000 cash or surety. That means you don't have to come up with all the money. You can go through a bondsman. That's where the surety bond is. You will use the phone in a few minutes to try to post the bond. The jail's also going to give you a notice for your court date. Your court date will be, we're going to get you that court date. May the 5th. May the 5th at 8:30 a.m. will be your court date. Do you have any questions?
Yes, sir. If I bond out recently, right now, I stay in Texas. Would I do it over Zoom or would I have to come back here? Because I don't quite know. I haven't been arrested in a while, so I don't know how it goes now.
Judge Garcia doesn't do criminal court over Zoom, but my question is this, well, at least not out of custody. My question is, if there's no information filed yet, because that's just such a recent court date, I really don't want him coming back for nothing. So it's a preference to give him, well, if he's in custody, he's going to want the earlier court date. I can give you a June court date instead of May.
Can I get a June court date?
But here's the thing you need to understand. If I give you the June court date and you don't post bond, you still don't come to court until June.
I'm gonna post bond. Ain't no
Okay.
problem. I'm gonna bond
All
out.
right,
You can
so-
give me a June court date. I set
Mr.
June court. So just give me enough time to get my license.
Okay, Mr. Bell, any objection to that?
No objection to a June court date, Your Honor.
The June court date then will be June the 2nd at 8:30. They'll give you a notice for June 2nd. Okay, sir?
Yes, sir. Thank you, sir. I appreciate it.
Yes, sir. Have a good day. We have Ashton Johnson next. Mr. Johnson, good morning. Mr. Johnson, you're here for first appearance because you've been accused of one count of battery, one count of petty theft, and one count of misdemeanor assault. Mr. Johnson, I read the complaint. I had some probable cause questions. I emailed or texted the attorneys about this morning, specifically on the petty theft. Mr. Bell, anything from the state on the petty theft probable cause?
The state will concede the PC issues on the petty theft. We would like the court to be made aware that this gentleman is out on bond in case 25 CF 321, and the state would move to revoke his bond.
Thank you. Mr. McDaniel, anything?
Your Honor, I was just, I mean, I think, the assault and the battery is kind of weak, but, I do concede this probably cause for it, so I don't,
I don't think our analysis is that different. It doesn't appear to be very strong, but there's certainly enough there for probable cause. And the problem is, as Mr. Bell said, Mr. Johnson's already out on bond. Mr. Johnson, I'm going to find no probable cause in the petty theft. There's no evidence that you stole the phone other than the phone went missing. And if every time I lost a remote control yesterday, or one of my kids probably stole it, but I don't have probable cause for that. So I'm going to assume it just got lost. There's no probable cause on the petty theft, but there is probable cause for the other two charges. Your bond's going to be $5,000 on each of those. Don't try to post it, Mr. Johnson, because you're already out on bond. As Mr. Bell said, I'm revoking your bond in 25-1668 CF. That means you have no bond in that case. You've got a condition, a bond in new cases, and you've got a condition to have no contact with the alleged victim in the new cases, who I think is your mother. So right now, you've got no bond in one case, and you've got a bond set in the other case. As far as your court date on your new cases, it would be the 6th of May would be your court date. 6th of May. May 6th at 9 a.m. would be your court date. Mr. Johnson, but now as far as your court date in the other case and the one that you have the bond revoked in, I'm just going to ask Mr. McDaniel to notify your attorney in that case. That court date should stay the same as it was before your arrest yesterday. Mr. Johnson, do you have any questions?
Yeah, is there any way if those charges are dropped soon, not the petty theft, but the ones that are just charged, is there any way I can unrevoke the other
Yes.
bond? Because this was just a big misunderstanding.
That is possible. If the state decides to drop the charges, it's possible Judge Garcia would reinstate your bond. It's possible. Yes, sir.
Like for the bond, $10,000 that was already paid.
He just said yes.
Yeah, the one you're on
okay, I'm
bond
sorry.
on, it's possible. I'm not saying it will happen. I'm saying it's possible if the state decides not to go forward with the new charges. That'd be a decision for Judge Garcia.
Yes, sir. Yes, sir.
All right.
All right, thank you.
I said no contact. Yeah, no contact with the alleged victim. It was his mother.
Your Honor.
We have,
For clarification, he is out on bond in 25 CF 321.
what did I say?
You said 20 CF 1668.
Yeah, I'm looking at the wrong case. Mr. Lawrence is the one at 1668. So Mr. Johnson was 25 321 CF. Mr. Michael Lawrence is next. He's the one that's on probation in that case.
Yes, sir.
Michael Lawrence. Mr. Lawrence, good morning. Mr. Lawrence, you're here for first appearance. You've been accused of one count of depriving of the use of 911, a grand theft, and a felony battery. I've read the complaint. In your case, I have probable cause questions on the grand theft. So let's hear from the attorneys on that issue first. Mr. Bell.
Yes, Your Honor, we have spoke to Captain Scarborough of Mariana PD. He has stated that he is going to send in an amended complaint with the value of the phone to alleviate the probable cause issues on the grand theft charge.
Okay, thank you. Mr. McDaniel, anything?
No, whatever the court wants to do on that issue is fine.
So there's no probable cause on the grand theft. There's probable cause for petty theft. The officer never mentions the value of the phone at all. You have to allege the value of more than $750 or another basis for grand theft, which he doesn't do, he or she doesn't do. So I'm not going to hold you on that. Actually, I'm going to find probable cause for the misdemeanor version, which is petty theft. So your bond, Mr. Lawrence, will be $5,000 on the depriving use of 911, $5,000 on the petty theft, $10,000 on the felony battery. Do not try to post the bond. The reason I'm saying don't try to post the bond is because you're already on probation in case 25-1668 CF out of Bay County. I'm asking Mr. Bell to notify the Bay County Probation Office of your arrest. They have 7 days to seek a warrant. Mr. Lawrence, I don't know if they will or not. If they do, and if they get a warrant, we'll see if the judge that's over the VOP puts a bond on the warrant or not. So I will see you in 7 days. Next Monday, we'll see if they have a warrant or not. But right now, don't try to post bond because you wouldn't get out even if you posted it, because it appears you may be charged with violating your probation. In your new cases, we're going to give you a court date, Mr. Lawrence, for May the 5th at 8:30 for your new Jackson County cases, and I'll see you a week from today. Mr. Lawrence, any questions?
Yes, sir. On that petty theft, she got her phone back yesterday, sir.
Yeah,
No.
Don't tell us
She
how
got-
she got it back, but
I'm saying she got it back though.
that may be something that'll be something the state looks at and considers and how to handle that charge. You still got the allegations that you violated your parole, your probation, okay?
I already know that.
All right, thank you, Mr. Lawrence. We have Kenneth Smith next. Mr. Smith, good morning. Mr. Smith, you're here because I believe you're being brought back just to be arraigned on a violation of probation. Is that right? Corporal?
Yes, sir.
So, Mr. Smith, I'm just going to arraign you today. What that means is I want to get you a lawyer appointed if you're asking for one, so we can get your case moving. Mr. Smith, in the violation of probation, would you like to have an attorney appointed to represent you?
Yes, sir.
I'm going to appoint the Public Defender's Office of the 14th Circuit to represent you. Mr. Smith, listen to Mr. McDaniel, and I'll see if you have any questions in just a minute.
Judge, I've seen that the motion and all had been filed, but I didn't see an order that was ever done. I thought you usually do them that morning, but we assume it's going to happen. So we're going to enter plea of not guilty. Ask to sit this on the May 7th pretrial docket. And there'll be an attorney from the Public Defender's Office to come by and visit Mr. Smith.
I may have just misunderstood the jail. I assumed he'd been served. So has he been served, Corporal, with the VOP?
No, not yet.
So he's not being brought back for an arraignment. He's being brought back to see the status.
Correct, it's 7-day hold. This is the 7th day.
They told me it was on violation.
All right, so
Violation.
there's a waiting warrant, a pending warrant that says it's submitted to Judge Garcia. Judge Garcia is out of the office for the next couple of days. And it's based solely upon the charge of aggravated battery. That's the sole basis for the alleged violation of probation. So let's go look at ag battery, because I don't know if I first appeared on that. I don't think I did. Let's see if
No,
there's
treason.
probable cause. What'd you say, Mr. Smith?
No, you didn't do that.
I think I
I would-
remembered that if I did. Let me see if there's probable cause on the aggravated battery.
My mom and them took, proof of where I was at to the state attorney, and they have proof of it. I mean, if that matters.
Yeah, let me see. The judge has found probable cause, but let me see what the evidence is probably the better way to word it. Before I signed a no bond warrant, I want to know the amount of the evidence in the new charge, if I can find it here. Do y'all have a case number on the new case?
26196 CF.
There it is right there. So let's see what the new complaint's all about. And the judge has already read it, found probable cause, and set a bond of $15,000, it looks like.
That was a weekend judge.
Judge Pittman. Oh, I thought you said Judge Pittman. I was gonna say, I thought she retired.
It wasn't good. It was Goodman.
So the complaint alleges that you allegedly, Mr. Smith, struck a Miss Bowles and broke 2 of her teeth.
Says I open hand slapped her twice, but I mean, I got proof of I was
Ms.
at work.
Ms. Smith, don't say too much about anything. He's just letting you know what he's.
Yeah, I'm just letting you know what the basis is. So yeah, there's more than enough there to justify the charge, which the judge has already found that. I'm not second guessing that, but I am going to sign this no bond warrant. So they'll get that warrant started on you hopefully sometime today, Mr. Smith, but everything I told you is true. You've got the attorney appointed to represent you. Did we go through that process? How far did we get in there, Mr. McDaniel? They get the public appointed?
Yes. Yeah,
You got your court date coming up, the public defender's office appointed, and they'll get that warrant served on you, but I'm going to go ahead and get the process moving because I don't want you sitting there a week or two waiting on this warrant to be served. We'll ask the sheriff's department to serve it today. Any questions, sir?
No, sir.
All right, sir. Wish you the best. After Mr. Smith, we have Dawn Prince. Ms. Prince, good morning. Ms. Prince, you were first appeared this weekend by Judge Young. He set you bonds in your new charges, ma'am. There was a request for you to be held for a potential Nebia motion, ma'am. And I think Judge Young explained that to you. So let me see what the state's position is, ma'am, and we'll go from there. Mr. Bell?
It's actually gonna be me, this argument, but we request that the court grant this Nebia motion. The complaint says what it basically says about her bringing the drugs into the institution. Additionally, there is evidence from a post Miranda statement where she admits that she was getting paid to actually bring this stuff in. So she has knowledge, she has the intent to bring this stuff into the institution. I think there was 64 grams of methamphetamine, 33 grams of cannabis, I think in total. And additionally, to sort of help the state's argument, over the weekend, during the first appearance, she actually was requested to give a random UA over the weekend. And she said something like, I don't use the drugs myself. We just basically said that the court take all this evidence into like grant the Nebia motion, and we'll just leave it up to the court to decide for that.
So help me understand the logic. Not using the drugs hurts her because the argument is that they weren't for personal use, they were for transfer?
Yes.
It was
Okay.
wrong.
I mean, the basis for a Nebia hearing is some kind of evidence the state possesses that says that she's, the monies have been illicitly gained. She doesn't have the money. So I don't even think she's going to make the bond anyway. So I don't even know if there's a need for a Nebia hearing. It's going to be up to her aunt or something that's in Colorado that I suspect she's going to be in there weeks trying to get it. So, I mean, we're not going to do a major objection, but it should be some kind of evidence, something, the court can rely on that says basically that, these monies are coming from illicit gains. And you know, the case facts of itself have nothing to do with her. She had no money on her, I don't think, when she got arrested. So it's not really showing that, you know, she had some kind of illicit money. So,
Your Honor, if I may.
sure.
So she didn't have any money on her as the complaint does state, but she was doing this for the intention of gaining money. In fact, the actual part that I mentioned post Miranda, she says, the defendant provided a sworn post Miranda statement indicating inmate Dana Douglas asked her to introduce the contraband into the institution, and the defendant would be paid $275 per package that successfully entered the institution. And I believe there was 8 total packages, 8 times 275.
8 or 4?
4 contraband packages on that day. And then they also intended to introduce, well, 4 she had, but she also intended to introduce 4 more the next following days.
So, Ms. Prince, within the last 2 or 3 weeks, we've been notified by the state attorney's office that they're asking for a Nebbia. A Nebbia is a federal case. It's really not state of Florida law, but there's a corresponding state of Florida statute that says the judge can and make inquiry into the source of any bond or bail funds. So that's the correlation there. Well, a couple of weeks ago, the judges were advised that the state attorney's office is going to be asking for source of funds hearings or Nebbia hearings in trafficking cases, which is one of the charges you have is a trafficking case. This is not your typical trafficking case. I think Mr. McDaniel's right. This is probably not going to be an issue in this case because it's not your typical trafficking, and therefore you don't have a typical trafficking bond. The bond the judge said she was lower than you probably would have gotten if it was a normal trafficking case.
Yes,
Just because of what you're accused of. However, regardless, the state has the right to request the source of the funds, and you have to provide evidence if this motion is granted of the source of the funds. It doesn't mean you can't post bond. It doesn't affect the amount of the bond. It simply means that before the bond is accepted, you have to present evidence on the source of the money, showing it comes from an aunt or a relative or a friend or your savings or sale of a car or house or wherever it comes from, just to show that it doesn't come from the result of sale of an illegal drug. So I'm going to grant the motion because I think they have the right to it, ma'am. All it means is before you can post bond, you would need to contact your attorney and say, hey, here's where the money's coming from, and I have the right to post bond. So my question, Mr. McDaniel, is if she gets the ability to post bond before arraignment date, what process, who would she contact? What's the process
I
y'all have?
advise her to let the jail know, and the jail would let me and public defender's office know that if she had someone that could make that bond, but I'm under the impression she's probably not going to be able to. But if she does do it before arraignment this next week or so, they'll let us know.
Ms. Prince, you've got the right to post bond, ma'am. It's just that a court, either myself or Judge Garcia would review the source of those funds before you get to actually post the bond and be released. All the other conditions the judge put on you, the random urinalysis, that still applies. Do you have any questions?
No, sir.
Anything from the state or defense?
No, Your Honor.
No, Your Honor.
All right. Wish you the best, Ms. Prince. We have Barry Blanton. And this warrant's already been served, correct?
Yes.
Mr. Blanton, good morning. Mr. Blanton, you're here to be arraigned on the charge of violation of state probation. Mr. Blanton, I'm going to make you aware that you've been accused of violating your probation, and I'm going to appoint an attorney to represent you in that allegation if you're requesting one. Would you like to have an attorney appointed to represent you?
Yes, sir.
I'm going to appoint the public defender's officer to represent you. Mr. Blanton, listen to Mr. McDaniel. We'll see if you have any questions in just a second.
You know, we're going to plead not guilty. I set this in the May 7th pretrial docket, and I advised him there'll be an attorney in the PD's office that'll stop by and see him prior to that hearing.
Thank you, Mr. McDaniel. Mr. Bell, anything from the state?
No, Your Honor.
And Mr. Blanton, do you have any questions?
For the public defender's office, I need them to contact Gadsden County. I've been being held there for the last 7 months on new charges.
Yeah, okay. And make sure that when you talk to your attorney, that the attorney is aware of that. That's something the judge usually does want to know. But as far as everything that Mr. McDaniel said, your court date and everything, the attorney seeing you before the court date, all that's accurate. And any questions about anything else?
No, sir.
All right, sir. Wish you the best.
Thank you.
Yes, sir. I think that's it for first appearances, Corporal.
Yes, sir, it is.
Anything I may have missed?
No, sir.
All right, I am signing the.
All right, that wraps it up for him. Good morning once again, everybody. My name is Dan. This is TCF Live on a Monday. Solidly an hour 2 already. These days move by so fast. Let's do this. Let's go to Fulton County, Georgia, Judge Alex Manning.
At this moment.
Outstanding. Hold on. Or if I mute it, it's not. Outstanding, Mr. Caldwell. You have a motion?
Yes, Your Honor. Mr. Caldwell, his case is still unindicted. I know I'm covering for my husband, Brian, but I know he filed a motion for Mr. Caldwell to at least see if we could possibly modify his 24-hour house arrest because he has a job offer. And so we were just wondering if we could possibly do something about the curfew. Maybe I could talk to the state, but we have proof of all of that. He has a job offer. So since he's here, we were hoping maybe we could address that.
What it says the state.
Your Honor, the state, in connection with, as long as there's proof of these matters, we don't have with all the other terms and conditions, we don't have an objection in connection with work-related activities.
What does it look like, Bostic?
No new arrest has been on for over a year.
Yeah, it's been over a year, Mr. Jenkins.
All right, well, okay, well, our position hasn't changed regarding, letting him work.
Is that fine? You got a job? You want to get a job?
Yes.
All right, let's see. How about we do that? I don't know. Let's think about it. Everything's muted, so I don't know. All right, so we'll remove all those conditions. Well, we'll keep no drugs, no alcohol, no weapons, no replicas of weapons. Curfew, how about 9 PM to 6 AM?
I think that's fine. Can we just have that pretrial, maybe, there could be an exception for work. I don't know what the hours of work. Oh, and you're already out. Okay,
There you go. Just be home 9 PM to 6 AM.
okay,
All right? And you go out for work, anything like that, except for getting in trouble.
Okay.
of course.
Obviously, you have to making sure that Second Chance has that information.
Yeah, so here's what you need to do. If you got a job or if you move, you got to keep Second Chance informed. So if you have a schedule, give them the schedule.
Okay.
If I were you, I would text, email them or something. Hey, this is my schedule, and tell them ahead of time. Because if you don't, then they'll show that you're not in compliance. It looks like you've been in compliance, okay?
Yes.
All right. Thank you, sir. And also if you change your address, so if you have a job, just you have a card over there, Second Chance?
I do.
It'll give you a card that way you can call. Thank you,
We'll,
sir.
we'll get all the information to everybody. Thank you, Your
Yeah,
Honor.
everything just needs to be home then. He can work, personal needs, stuff like that.
Great.
Anything
Thank
but
you.
hanging out.
Thank you.
All right, thank you. Yeah. No, I know. Yeah.
Okay. So
Now look, all right, so I've got, number 2 is Adrian Cruz Castillo, 25 PI 003115.
Good morning, Judge.
Does your client need an interpreter?
No, yeah.
Okay. I'm saying, I'm real rusty.
Name is Drew Niner. I'm here on behalf of John Sperling.
All right, go ahead, Second Chance.
He's had a few violations, a few dead batteries. He's had 3 dead batteries in the past 60 days. He's been tracked at Home Depot, shopping centers. And he claims he's homeless. We don't have a home address for him.
What did you say, Bostic?
no new arrests been on since 10/10/25.
All right.
Yes, Your Honor. My understanding is we have had issues with the address. We have filed an updated address. I have a copy for the court.
Was that, map? So you got to keep them informed of your address where you're living.
You understand?
No, I didn't understand.
Said you have to keep Second Chance also informed of your address.
From the beginning, they didn't clarify that with me. Last Monday, they called me and they told me that I needed to update my address. So, which I came on Wednesday because I did that on Wednesday.
And we did update it right away, Judge, so.
Okay, always make sure if you move that you update it with second chance, okay? No contact, same restrictions, no contact with any person under the age of 18. You have a 24-hour curfew except for work and any legal appointments, okay?
Okay, Your Honor, and I did have one request.
Okay.
So we have filed an updated address here in Georgia.
Right.
We are fine staying in Georgia. Mr. Cruz does have a lot of family out of state, and we were wondering if it'd be possible to allow the bond condition for him to reside out of state.
What state are we talking about?
North Carolina is fine. I mean, I don't know anybody here in Georgia.
Mr. Jenkins, what's the state's position?
As long as he stays from the, away from the listed victims and witnesses in this case, we have no objection. He's got to, comply with all the terms and conditions of bond, whether he's in state or out of state, so.
All right, we'll add the condition that you stay out of the state of Georgia. The only time you can come back is to Fulton County for court or to see your lawyer. All right?
Thank you.
So do not cross that state line. You come back to Fulton County. All
Yes.
Okay, thank you, Judge.
right, have a good one. All right, Lewis Raymond, 24 PI 004146.
Your Honor, Anthony P. for Raymond Lewis, Public Defender's Office.
All right, let's see. What we got, second chance?
We have no violations within the past 60 days for him.
All right, preach. What do we
No
got?
new arrest, 10/9/25.
All right. Go ahead, I'm listening.
Judge, it appears that he's been in compliance. I've got a note here that this is only a compliance only hearing to make sure that he's in compliance, and it appears that he is in compliance.
See, step. Do we have something else? We, no? Sorry, did you check it? Okay. All right, where you want him to sit? All right, so just hang out a few minutes, okay? Because they have a question about something that came up on his.
All right.
Okay?
Thank you.
Okay, all right, we've got Lauren Chambers, 26 SC 001641.
Morning, Your Honor.
Good morning, go ahead, second chance.
We've had a few violations. She's been tracked, few restaurants, Taco Bell, Chick-fil-A, Krispy Kreme, Home Depot, and Pets More Than Walgreens in the past 60 days.
What about it? Say. What about it?
No new arrest, 10/3/25.
All right, go ahead, counsel.
Thank you, Judge. On November 6, 2025, I did file a motion to modify the bond conditions, specifically to remove the ankle monitor. My client has absolutely no record. I understand that, to me, I find that the bond conditions were oppressive, meaning that, she couldn't do the minor things that somebody who has no record and should be considered not a felon couldn't do. She can't go to Taco Bell, she can't go to.
But she did go to Taco Bell.
Well,
And
I'm
Chick-fil-A.
just saying, Judge, I'm trying to get some relief here. So she can go to Taco Bell, or she can go to Krispy Kreme, or she can go wherever grocery store to do the minor things. How are you gonna live your life? How are you gonna live your life? And even though she's been trying her best, I'm asking for this court to relieve her ankle monitor. I do understand that the charges are serious, but the simple fact that she's charged with something doesn't mean that she should not be able to live her life in the meantime. Her case has been indicted. It's assigned to Judge Paul. I did want to make sure that we were transparent with the court on that. But I filed this motion on November 6, 2025. I'm just asking that the court relieve her ankle monitor and allow her to move about while her case is pending.
What says the state?
Your Honor, we'll leave it in the court's discretion in this matter, other than as long as she, all the other terms and conditions of the bond are appropriate in connection with no further violations of law, no contact with the listed victims and witnesses in this case, Your Honor, and the incident location.
We have no problem with that. The last thing I wanted to say, Your Honor, was the fact that her grandmother is receiving cancer treatments and she hasn't been able to take her grandmother, which she would like to do, and be there for her, which is just one of the other things that she would normally do if she was not, were not under these restrictions. Your Honor. Thank you, Judge.
Okay, we'll be glad to move.
All right. Is that an order I need to write up, Judge, or?
No, we'll do it.
Okay.
You got somebody here to take it off?
I can take it off.
Okay, you want her to wait till the end or?
I can take it off now.
Thank you, Your Honor. May I be excused,
Yes, sir.
Your Honor? Thank you so much. In the hallway.
All right, let's see, number 5. 25 PI 008174, Darius Jackson. Darius Jackson.
I think he's still in custody in Henry County.
All right, is that the last time you checked?
Where do you have him at there, second chance? Can you look?
As far as last week, he was in custody in Henry County.
When was that? When?
He was taken in, he was in Henry County, arrest 11/7/25 for a probation violation.
You don't know if he's still down.
When did you have him?
We haven't tracked him since he got into custody in Henry County.
So they took it off then?
Yes, ma'am.
I have no idea, Judge. Anthony Pete for Mr. Jackson, for the Public Defender's Office. I was not aware that he was in Henry County Jail, so. Or that he had even been in Henry County Jail.
Okay. Mr. Jenkins, what would you like?
Well, Judge, until we can confirm such, I mean, obviously we say we won't ask for a bench warrant at this time if he's, last information we have is the fact that he is in custody in another jurisdiction in this case. And so I would just request a further notice for further information and investigation in connection with his whereabouts are. And whether he's received certainly good notice of this calendar.
All right, and also, if you speak with him, Councilman, we can get his ankle monitor put back on and we'll get him on the calendar and see how he's doing,
Yes, Your Honor.
right?
The second chance, never device.
Yeah, he didn't know, he didn't even know he was in Henry. Did you guys get his ankle monitor second chance?
Not yet. We have not.
Henry County, sitting down in Henry County.
Judge, I know that sometimes they don't take them off. They just leave them on, so. And it's just, it doesn't charge. It's just on their ankles, so.
Let's say, since they're buying them off Amazon. That's. All right, let's see, what about which Chavion Bostic? Printez Bostic 25 PI 008543. Hold up, Mr. Bostic.
Your Honor, Anthony Pete for Javion Bostic from the Public Defender's Office.
We got a second chance.
We have no violation other than a dead battery he had for about 47 hours, but he did call and tell us somebody took his charger and came and got another one.
Judge, in regards to Mr. Bostic, no new arrests. He was transferred to Richmond after this arrest.
Jenkins?
Nothing from the state at this time, Judge, other than further notice and keep up the good work.
Judge, I would move the court to consider removing the ankle monitor. It looks like he's been on for about 6 months. He's been compliant. I've got a note on the calendar at least that the ankle monitor is due off on April 16th, which we are past. I would ask that the court consider removing that ankle monitor.
First of all, thank you, Judge. I am actually curious as to these notes on the calendar as to due to me for removal. How did those notes get on the calendar and
So
who's
first
responsible
appearance.
for those notes?
At first appearance, some of the judges are checking the box. It says, I don't know if they're doing it automatically, but it's not necessarily paying attention to some of the offenses.
Okay.
So, now we're called up, so if that's on some, they'll be on the compliance calendar prior to that date.
Okay. I mean, I don't know, right. So you're saying that
There's a new bond order. The bond order now gives a 6-month provision for the ankle monitoring and the pretrial services. Unless the judge at the time who is granting that bond sees fit to extend beyond the 6-month period, you'll see the 6-month mark on the calendar. That's the date.
Oh, that's due to the change in the, oh, okay.
And as a,
His first arrest, is it?
I do not know, Judge, but I do know that he has been on this monitor for 6 months and appears he's been doing well.
So we'll keep your other bond conditions in place. Let's see. No drugs, no alcohol, no weapons, no rep of weapons.
It looks like it.
That's some new stuff.
Stay away from 1125 Hammond Drive. No further contact Montrez, Montrez, Frank. You hang out, you can get it off of you, okay?
Thank you.
All right, have a good one.
Just hang on.
All right, I got number 7, Jaden Simeon. 25 PI 008557.
Do this. May I inquire of this defendant, Your Honor?
Go ahead.
No, well, you have it, all right.
Okay.
You have an ankle monitor?
Judge, he informs his lawyer hasn't arrived yet.
So who's your lawyer?
I'm not sure.
Christopher Campbell is the name I had, Your Honor.
You have his number?
Yes. Yes,
Look back there. Is he back there?
no, my girlfriend got his number.
No, I have his number. Probably good that you get his number since you're the one in trouble, right?
Correct.
So why don't you go up so I can get the number and see if he's on his way?
All right.
All right, thank you. All right, position 8, got Kai Burton, 25 PI 008567. All right. Who's your lawyer?
Ain't got one.
Judge, I believe that it is indicated that it's Emma Gibson who's conflict at this time.
Right.
I know that she's getting ready to start working at our office. So, but I believe this is a conflict defendant.
All right, let's see, good. What do you got, second chance?
He's had 8 dead batteries in the past 60 days.
But why don't we just keep it on then? We'll see how you do when she comes over to this office. How about that?
Yes, ma'am.
All right, so what's the problem with it being a dead battery?
My charger messed up. I need to call him.
Oh, yeah. Man, let's up with it. I don't think you. Go ahead.
Hmm?
Go ahead.
Oh. No, my charger messed up. I was supposed to call and got another one, but I just ain't had the time to call.
Danny's been working all the time or?
Yes, ma'am.
In custody?
So you hadn't had time to go by at all?
No,
I think there, aren't y'all open 24 hours?
we are.
Oh, God. So how about like that? You go by then?
Yeah.
If he's got another charter, he'll give it to you today. Let's reset him now for next calendar, okay? What we think about him.
They cut it off when he's doing that custody, Judge? Bond order, another 6 months?
Yeah, until. Then we'll talk and figure out how we'll do. Okay, go ahead and give you an equal, charger, so make sure you get it charged. All right, number 9. Got 25 PI 008571 Montagues, Colzie, COLZIE.
Colzie, come to court where your bond will be forfeited. Colzie.
Yes, Your Honor, subject to good notice, Your Honor, state request bond forfeiture bench warrant issue.
Austin, do you have anything else?
No new arrest 10/20/25.
We'll check to see if there's notice of return. Sometime we check it up.
Judge Anthony Pete for Mr. Colsey for the Public Defender's Office. Had no contact with this person, Your Honor. I cannot count for their failure to be here. It was my understanding that there were no violations, though.
Oh, I don't know that yet. But how's the violation?
He's not been tracked since March 6th.
Yeah, there you go, there's a violation. And this is the contractor, looks like a Judge Farmer. So we'll put this one back on too. We'll check to see if there's any notice or anything's been, anything was come on, not also on the bench. All right, they got Kiara Barney, 25 PI 008780.
Owen Davis.
Yeah.
Yep.
Realize I already turned the page.
Mhm.
And we'll get.
Once again, everybody, this is TCF Live on a Monday. Hope you're all enjoying. I'm going to stick with Judge Manning here for a while because we don't often see her. She's not streaming every day, so we're going to ride here for a little while longer.
She's had a few violations. She's ordered to stay away from Lululemons in Fulton County. She's been tracked at a few of them in the past 60 days.
What are you?
Barney, no new arrest 10/28/25.
Ms. Jenkins?
Your Honor, it appears that we're not quite at the removal date yet. And so, at this time, we'll leave it in your discretion and, as long as she, complies with the remaining, issues in connection with her bond conditions, Your Honor, so. I see a due to remove per, I guess, these new bond orders on April 25th, so that is,
Then let's extend it. Go ahead, counsel.
Judge Anthony Pete for Ms. Barney. Judge, we would ask that the court consider removing that early. She tells me that she has a doctor's note. She is pregnant and the doctors and the doctor.
Leave my courtroom pregnant.
And apparently the doctor feels it'd be a good thing to have that ankle monitor removed. She has a letter, is my understanding.
Well, we'll go ahead and take it out. That's good for the baby.
Thank you.
Okay? You go by there. When's your next doctor's appointment?
Tomorrow.
Yeah, you can go ahead and let him take it off today.
So just hang on.
All right, all right, let's see, Stephanie Lowe, 25 PI 008700.
Your Honor, that is my case. I have filed a motion to withdraw. My understanding is that Ms. Lowe no longer wants me to be a part of the case.
And when you want to terminate his services?
Yes, ma'am.
I think you sent me an order.
I sent you a consent one, but I have a regular, just,
All right, if you want to hear it.
okay. Thank you, Judge.
All right, go ahead. Have you hired anybody else you plan on it?
So that's the other thing I wanted to speak to the Public Defender's Office to see if I qualify. I've been in constant contact with them, so.
Okay,
She'll stick around, Judge. I'll see if she qualifies.
all right, let me see how this going. What do we got on?
Thanks, Judge.
Thank you. I appreciate it.
What we got on her second chance?
Oh, we have no violations within the past 60 days for her.
No violation. They let him file that? All right, what we got, Boston?
Who's this, Judge?
Stephanie Lowe, Ms. Lowe.
Oh, no new arrest 10/23/25.
Mr. Jenkins.
Well, Your Honor, I see a note that we'll leave it in the court's discretion. There's a note for removal on April 22nd. So,
All right, go ahead, for yourself, go ahead.
I was just gonna ask the court, can I please, since I've been in compliance and it's in 2 days, may I please come off my monitor today if that's possible, so.
We'll go ahead and have it removed. I hope some of the lawyers paid attention. That's how you. All right, so you just hang out, he'll get it off.
Okay, thank you.
He wants you to hang around and talk to them about his project.
Actually,
All right, thank you.
I'm gonna send her by the office.
Oh, okay. All right, so I've got, position 11, 25 PI 008723, Alana Davis.
Alana Davis, come to court or your bond will be forfeited. Alana Davis.
Is that one of the PD cases?
It is not, at least not to my knowledge. I don't have an attorney that listed that as their case.
I don't have anybody. I'll be returning those. Jenkins.
Your Honor, subject to good notice, they request bond forfeiture, bench warrant issue.
It just has Attorney Brown.
Is that Attorney Brown's case, Your Honor?
That's what it says on the, that was in October 2025, first appearance.
Sometimes we keep the cases, sometimes we just represent them for the moment of first appearance. I don't know whether there was a conflict or anything of that nature that is keeping us from having a file on Ms. Davis. So, but I did not have an indication that we were representing that individual.
Okay, all right, well, we'll look it over and see, we'll issue a bench warrant. I've got Christopher Jones, 25 TI 008895. You got a second chance,
No violations within the past 60 days.
but what about?
No new arrests, 10/31/25.
Look it together.
Yes, there's that, hold for probation violation in Fulton.
Got a probation violation for me. It was issued by Judge Edwards.
Is there a warrant at this time, Your Honor?
Yes.
Yeah, it's on his GCIC.
Is there an actual warrant at this time, Judge?
Send with me, no, but yeah, I got just print it out. So where would you guys like to wait?
I got a court. I got a court.
You want a case number for that?
If you don't mind, Judge.
26000466 PV.
Thank you, Your Honor.
All right, thank you. All right, I got Towns Covington, 25 PI 0089.
Well, friends, no Judge West this morning, so we don't get our Monday fashion show there, but we did get some from Judge Manning, so that's always a joy. I'll keep an eye on this court, but let's move on. We've been here for a little while. Let's go back to Michigan and Judge Prill, new contestant there.
King, file number 267401H. It's time to date from Ms. King's sentencing. She is present in the courtroom, represented by Attorney Elizabeth E. Weisenbach. People are represented by prosecuting attorney Timothy J. Rutkowski. On February 2nd of this year, the defendant entered a no contest plea to domestic violence third offense. Ms. Karen Edwards prepared a pre-sentence report dated March 25, 2026. Court has also received letters that have been provided on behalf of Ms. King, including letters from Raymond King, Ashley Collins, Nicholas Holzwart, Holzwart, Jenna Genna Rachi, Rathje, Brooke Arns, and Ashley Adams. Ms. Weisenbach, have you declined the opportunity to give the pre-sentence?
Yeah.
Are there any additions, deletions, corrections, or objections to the report other than guidelines?
No, thank you.
Any objections to the guidelines?
No.
Ms. King, do you agree with all that?
Yes, sir.
Mr. Rutkowski, any objections to the report as well as guidelines?
No to either question.
Thank you. Ms. Weisenbach, anything you'd like to say on behalf of your client before the court imposes sentence?
It hasn't been that long since your Honor has had Ms. King before you. I understand that, so there isn't much to add, except that there's been a development at home. When Ms. King went to jail, it was a bit of a shock. We had looked at a recommendation of 30 days and Your Honor gave her 6 months. She was prepared to leave her children for 30 days with her husband's care. There was also school for one of her children. She needed work release. The court granted that, appreciate that. She has been on work release. But here's the rub. Sometimes people don't always know what a mom does until there's no mom to do it. And Mr. King, to his credit, has fully gathered everything that he did not necessarily know about that his wife was doing for their 3 children. 2 of them are nonverbal autistic, and it was a heavy lifting that he's been doing. But unfortunately, despite his best efforts to care for the children, get them to school, he sought out a neighbor for help. He's done what he's needed to do, but the children still miss their mother, and doesn't matter what you tell them, they don't understand why she's not home. And children's minds, when they don't understand, creates anxiety, and they race and they come up with things that are not true, and they get themselves all worked up, especially little ones who already struggle to understand our world, which is 2 of Ms. King's children. That's why it was important last time we asked the court to adjourn, to give her people an opportunity to write letters to explain, this woman is the mom, she's the glue, she holds this whole ship together. And when she's not there, things fall apart. No one cares if the dishes get done or if the laundry gets done. Everyone cares about what's been happening to these children. She's not here to ask for anything for herself. She's been going to jail, she's been doing work release, and honestly, she hasn't had to do dishes or laundry. So it's fine for that part. And I'm being sarcastic because it's not fine. But here's the rub. It's because of these children that we are asking you to consider. Her outdate for that prior sentence is June 29th. The recommendation here would add almost another year or so to this time that she has to serve. Would ask this court to allow her on an outdate that is consistent with the June 29th, so she can go home to these children. It has been hard on them. I ask you to take special consideration of the letter that her husband wrote. He understands a lot more of what's going on now that she's not there to hold it all together and carry everything. Little details mean a lot, and that's what moms do. They handle all those little details and fill in all the gaps and makes life easier for everybody, and they don't even realize why life was easy. Ray King gets it now. He's here today because he's invested, understands, and he's asking as well for you to consider, for the sake of their children, an update that is consistent with June 29th. She has something to say also.
All right. This, what would you like to say?
First of all, I admit I am not perfect, but I am a great mother. And most people with divorce look a conflict, complicated marriages, but just like my husband, he is also not perfect. We both love our kids. Until jail, I've never had more than 13 hours away from my son. And 36 for my daughter. And that's only because my son's birthday.
It's a court will.
That's fine, go ahead.
Okay. I'll start over. First of all, I will admit I'm not perfect, but I am a great mother. Most people divorce over complicated marriages, but just like me, my husband is also not perfect. We both love our kids. Until jail, I've never been more than 13 hours away from my son and 36 hours away from my daughters. This was only due to the birth of my son during COVID. My oldest is 9 and has autism. Like a lot of other folks, I thought maybe it was the shots. Second child was normal. Then the third child was born and is nonverbal autistic. Until this third child, it was hard to even think about this process. This may also be a problem in our marriage. I know he loves me and our children, but this social emotional factor makes things a lot more complicated. My husband also has mental health issues. You have to stick to a schedule with children, even more so those who are on the spectrum. I make about $400 a week. I'm paying $160 for work release. It's almost half my income. Since I'm in jail, I also have to pay for all my medical out of pocket. I'm the only one working and still have to have paid for gas, car insurance, etc. But the worst part is for the children. They are the ones suffering emotionally with me not being around. My nonverbal son started becoming difficult at school. Daughters are not wanting to do their schoolwork. And all I'm asking is for some understanding. I'm asking for house arrest or to be released on June 29th.
Kowski, anything on behalf of the people? This is the victim.
Ms. Weisbach said Mr. King's here. I don't know if he wishes to address the court or not.
You wish to speak, sir? If you do, please step forward. That's fine, sir. That's fine. Could you please say your name?
My name is Raymond.
Mr. King, what would you like to tell the court?
But as you know, I do suffer from mental health issues. I can't see court until I can get her home. We don't have anybody to watch her kids. And she is a great mother. She is a great person. Didn't realize at the time of my actions, the consequences that they would bring.
What do you mean your actions?
Just being not a good person, I guess, and not paying attention to life as much as I should have done.
Go ahead, sir.
It's really miss them, miss her. And as of right now, my daughter she's at a 20% in her math and 30% in her English and stuff, and trying to get her back, we got her up in like 50%. And it's hard for her because she don't understand, especially my autistic child. My boy is 6 years old now, and he's lashing out at everything. And I know it's because he misses his mom. Like, you know, Sarah, we would just ask for like a house arrest or something so she could be home with her children, and then I could go off and work and seek help for myself.
Anything else? All right, thank you. Mr. Kowski, we have.
Your Honor, the pre-sentence report is accurate, gives you an idea of the entire picture of Rita and her family. I would point out a few things. One is that the case that Ms. King was on was a delay of sentence prior to this. This actually violated her delay, but that was an assaultive circumstance involving, you know, police officers going out there and just doing their job. And we have this circumstance. And I would suggest to the court that, you know, as it relates to the jail time, court can fashion whatever it deems to be appropriate. But the fact is that there is research out there that, you know, children that are in abusive homes, or at least homes involving domestic violence, tend to then have the children, either the boys become perpetrators, and the girls would latch onto somebody who does commit that type of crime. So, I mean, it's important that whatever sentence you fashion today, Judge, that you do so that with the idea of trying to prevent Ms. King from doing this stuff again. She understands, because this isn't like it's the first time. This is domestic violence number 3. So whatever you want to do that way, Your Honor, we would encourage you to do to fashion a fair and just sentence in this case, with the rest of the recommendations from the Department of Corrections being adopted.
Thank you. Ms. King's assaultive behavior begins March 7, 2014. Attempted domestic violence, which was eventually dismissed under the Spousal Abuse Act. That was number 1. 2019, domestic violence. But that was dismissed with prejudice. 2021, domestic violence, second offense, reduced domestic violence first. 20 days in jail. This is in 2021. 2025, where the defendant was on delay of sentence for resisting obstructing a police officer, assaultive behavior. Was granted delay of sentence. Sadly, February 2nd, 2026, unsuccessful delay of sentence, scheduled to 6 months with 2 days credit. And while on delay of sentence on December 20, 2025 is this case. And it's a domestic violence third offense. Defendant was clearly on delay at the time. The report indicates the use of an alcohol bottle against the victim. Defendant was intoxicated. Defendant took the children. Police were eventually called and charges were brought against the defendant. So it begs the question of the court, if you're so concerned about the children now, why weren't you thinking of the children in December? And I don't need an answer. In December, the children have the same medical conditions, mental health concerns. You decide to get intoxicated and use an alcohol bottle on someone with mental health issues. That's the question. And now the defendant comes before the court saying, well, it's my kids and my kids. I'm going to tell you right now, I feel terrible for these children. Terrible, because they're not given an example. What they're given is essentially the tools, sadly, that they will garner and use throughout their early lives to potentially act out or be the victims of domestic assault. Mr. Rutkowski is right. The research is very clear regarding families that have these types of issues. And I appreciate the fact that you're concerned about your children, but you sure as heck were not concerned of them on December 20th. And I don't know what your spouse did, but if he has mental health concerns and mental health issues, why in the world would someone be intoxicated and use an alcohol bottle on someone? It doesn't make any sense to this court. Your guideline range is a minimum 5 months to a maximum of 23 months. This is a straddle cell. The court could send you to prison for this. And I appreciate the fact that you're working. I appreciate the letters that have been provided, but it just begs the question why someone would do this and then all of a sudden claim, well, the children. You should have thought of that before you decided to consume alcohol, before you decided to lash out at the victim for whatever he did. And he may have frankly deserved something, but not to the extent of a domestic assault. It could have been, you know what, you're not following through, you're not doing this, I'm taking the kids, I'm going somewhere else, and I'm going to take care of them. It could have been that, but it wasn't that, it was much more than that. And there's a history of this. 2 prior domestic convictions. On top of that, resisting obstructing a police officer, and the officer was trying to do his or her job. I understand Ms. Weisenbach's arguments relative to being around the children and providing for the children, but it goes back to my point again. You should have thought of that back on December 20th. It will be the sentence of this court that the defendant be placed on a term of probation for a period of 24 months. Conditions of probation include the standard conditions, not to violate any criminal law of the government, not to leave the state of Michigan without prior approval of the court, notifying the probation agent at least monthly or such times and places the agent may require. No use or possession of alcohol or other intoxicants cannot enter bars or other places where they serve alcohol for consumption on the premises. You are to comply with all the rules relative to alcohol and drug testing. You are not to use or possess any controlled substance or drug paraphernalia unless prescribed for you by a licensed physician. Do not be around anyone that possesses those items. You are to complete any outpatient or residential substance abuse treatment when referred by the agent. You are to complete a substance abuse assessment when referred by the agent. You are to complete any mental health, domestic violence, battery intervention, or other recommended treatment following assessment by a qualified community-based service provider. Complete the Thinking Matters program or other cognitive behavioral program, with confidentiality. Regarding any treatment program, you're required to attend and disclose that information to the agent. You are to comply with the DOC's electronic monitoring program. No assaultive, abusive, threatening, or intimidating behavior. No verbal, written, electronic, or physical contact with anyone housed within an MDOC facility, nor the same type of interaction with anyone that's engaged in the behavior that constitutes a violation of any criminal law of any government. You are not to use any object as a weapon, nor you own or have under your control or area control a weapon of any type. cannot even possess an imitation weapon, can't be around anyone that possesses those items. You are to contact the supervising field agent no later than the first business day following your placement on probation or release from jail. Must comply with all written and verbal orders of the agent. You are to allow the agent to your residence at any time of probation supervision, or you're subject to a search of your person and property, including but not limited to your home, vehicle, or computer, without the need of a warrant if the agent has reasonable cause you have items that violate the terms of your probation. You are to report any arrest, please contact loss of employment or change of residence to the agent within 24 hours. You are employed, you are continuing to make a genuine effort to continue that legitimate employment at a minimum of 30 hours per week. Crime victims assessment of $130 is ordered. Probation supervision fee, $30 per month regular, $60 electronic. Court cost of $200 payable at the rate of $10 a month. A fine of $200 payable at the rate of $10 a month. Attorney fees are waived. $68 in state costs will be ordered. Probation is empowered and authorized under statute to effect your apprehension, detention, and confinement of up to 72 hours on reasonable cause that you have violated the conditions of your probation order. If referred, you must successfully complete any PA 511 programming based upon eligibility. And is she entitled to any credit other than the 1 day? No. Okay. Will be the sentence of this court that the defendant served 330 days, 320 days, correction, in the county jail, credit for 1 day served. Just a moment. The first 150 days must be served up front. Guideline range is 5 months. I'm giving her the low end of the guidelines to serve. The remaining time will be held in abeyance, depending upon successful completion of probation. But understand, if you come before the court on a probation violation, especially in domestic violence, and it's found that you violated the terms according to all due process, don't worry about county jail time. You understand? It's my duty to inform you of the right to seek leave to appeal. If you're financially unable to provide counsel of your own choice, court will assign counsel for your public expense. Please initial the receipt questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the court within 42 days. I got that 1 day.
All right, everybody. Once again, good morning, TCF Live. We are now officially in hour 3 of our 4-hour show. I really don't know where the time goes. It goes so fast. As Barbara pointed out in the chat just a little bit ago, In the Blind with Mike and Dan returns tonight, 7 p.m. Eastern, 4 p.m. Pacific. So please do check us out. She put a link in the chat for you. If you are new to the channel and don't know what I'm talking about, In the Blind is a brand new show done by me and Michael Groff, the TCF official weatherman slash sidebar panelist slash guest host when I can't do this show. And the shtick there is we have no idea what we're going to talk about until we are live. That at that point is brought to us by our producer, and it's a good time. So check that out with us tonight if you'd be so kind. Let's go back to Wade Mercer. So as I understand it, he was supposed to have had a trial this morning, but it sounds like they decided to do a plea at the last minute. So let's see what that's all about.
Driving while license suspended or revoked knowingly, second or subsequent offense. And Mr. McDaniel is here on behalf of Mr. Smith, Mr. Bell, and Mr. Mitchell are here on behalf of the state. And Mr. McDaniel, tell me where you stand, please.
Ms. Kent, 26-8 CT, we're going to plea to the court. No contest, and ask the court to sentence her with some extenuating circumstances. And she's going to waive right to jury trial and hold witnesses. She understands that she can sentence up to here in jail. And we'll go from there.
Okay, Ms. Kent, let me get you to raise your right hand, please. Ms. Kent, do you solemnly swear or affirm the testimony about to give in this case to be the truth, the whole truth, and nothing but truth, so help you God?
Yes, sir.
Ms. Kent, you're accused of a first-degree misdemeanor which means that the maximum I can sentence you to is a year in jail. We actually had a jury trial scheduled today. There was some concern about whether we had to have a two-part process or a one-part process, whether it's going to eventually be a bench trial or jury trial. Regardless, if it doesn't go to trial, we don't have a jury here today. So if you want a jury trial, we're going to make that happen. If you want a bench trial, we're going to make that happen. But if you enter this plea, there will not be a trial. You understand that?
Yes, sir.
If you're entering this plea, you're waiving your right to a trial, and you're also waiving your right to call witnesses on your own behalf and cross-examine the witnesses. There won't be a trial, so you don't get any witnesses other than witnesses for sentencing purposes. You understand?
Yes, sir.
And Ms. Kent, do you understand that the most I can sentence you to is a year in jail? But what I'll do is I'll listen to the state, I'll listen to Mr. McDaniel, I'll listen to you, I'll look at your driving record, your criminal record, and I'll decide what sentence I think is appropriate. I know that the state's offer, as of the last I was told in court last week, was
60
the
days.
state's recommended sentence was going to be 60 days. Is that still what you're recommending?
That's still what we're
So that's what they're recommending, and that has some value, but it's limited value. You understand all of that?
Yes, sir.
And you felt this is the best thing for you to do is enter this plea and waive those rights?
Yes, sir.
All right, so has she signed a waiver of rights form? I'm gonna show you a waiver of rights. You're entered a plea of no contest to the charge of driving while license suspended or revoked, second or subsequent offense, first degree misdemeanor. I'm gonna find the plea is freely and voluntarily entered with the advice of counsel. So Ms. Kent, I'm glad, Mr. McDaniel, let me hear from her, let me hear from you or from the state.
I will let you hear from her, but I will say that, I think Ms. Kent, has had a lot of things going on in her life. Lately, and I tried to put urgency in her to try to get her license back, and quite frankly, she didn't put the urgency that's probably needed in that. I know that Friday, she told me she went to the clerk's office and she, entered into some agreements with the clerk's office to make payments on some fines that she had, get her license back, and she's in that process now of trying to realize the urgency of it. So just let the court be aware of that. And I'll let Ms. Kent tell you the reason why she was driving and what's going on.
Okay, Ms. Kent, give me a second, look at this driving record, because I've not looked at it closely. I know that there was some priors, but let me see why your license is suspended. It looks like you have a 2023 DUI. Something related to that DUI is still out there, and that could be not paying a reinstatement fee, could be not doing something you had to do in the DUI, so that's part of a suspension. There's an unpaid traffic ticket in Jackson County that's causing part of the problem. Another traffic fine from Jackson County, and then your driver's license was canceled in March of 25. This offense was on New Year's Day of 26. And the last, I'm showing driving license suspended 1. So you got 99, 05, 12, 19, and 24. So that's 5 priors plus 1 no valid driver's license in 22. So the last driving license suspended would have been in July of 24, which was a year and a half or so before the current one. So the one thing I always look at is, did the person get their license back since the last one? So since July of 24, you have not had your license. So it appears you didn't have a license, got a charge, whatever happened with that happened, which we're going to look at in just a second. Continue to drive, got another charge. So I want to listen to you, but I want to know what happened to the one in 24 as far as the disposition. So it's 24-365 CT. And in that case, charged driving while license suspended. It looks like you were arrested. I think you must have entered a plea at first appearance, maybe.
She did, Your Honor.
And you were sentenced to 6 months in the Jackson County Jail. All right, so that's what I know so far. That's brand new to me. I didn't know that until right now. So I'm glad to listen to anything you want to tell me.
As far as that charge, I had some other charges.
Which charge are you talking about now?
The one in where the July charge, for driving on license suspended. I, had some other charges in Washington County. And the reason the license was, I never tried to get them back is because I was in prison. I just got out of prison in April of last year.
Okay, so give me some time frame. So I know that you were in court in July of 24. When did you go to prison?
About 2 weeks after that. I was here and I got sentenced to 1129 here.
Did you actually do this sentence in prison, this
Yes.
6-month jail?
Yes, sir.
So when you went on the felony, we just let you go and you did it, took care of everything at one time?
Yes, sir.
Okay, so you went in August of 24 to prison and got
Yes,
out
sir.
when?
April of last year.
April of 25?
Yes, sir.
Okay, I'm with you so far. Go ahead, please.
And since then, I have, I didn't have a license, so I had a problem getting a job. My mother was terminally ill, and I was helping with her. And in December of 2025, she was hospitalized. And on the 1st, I got a call that she was getting worse and I need to go there. That's the whole reason I was driving that day. I'm my only child. I don't have help with her. So that's the reason I got behind the wheel. I do apologize. I know that I shouldn't have been driving. But I was on my way to the hospital. I did state that to the deputies. They searched my car. They did not find anything. I have been trying my hardest to get things together since then. The license thing, I had to help I had to help bury her. And so I couldn't afford to get the license until now. Oops, excuse me.
Okay, when did your mother pass?
She passed on January 5th.
Okay, and this was January 1st.
Yes, sir.
And she was in the hospital on January 1st?
Yes, sir.
Okay.
I have all the paperwork.
So let me go back to the ticket and let's see what road you were on. And I noticed the time of day was 7:36 in the morning. I did see that.
Yes, sir. They called me and told me that I needed to come in, that we need to make some different arrangements.
Who is they?
The doctors from Sacred Heart Hospital at Bay Medical. They had contacted me and told me that I need to come down there, that we need to make arrangements.
All right, so you live in the Alford area?
Yes, sir.
Well, wait, I may be looking at the wrong one. I think I am looking at the old one. Let me go to the current ticket.
And at the time, I lived at 1723 Virginia Street in Alford.
South from Pike Pond Road, traveling south. So tell me, you left your home on, well, it says Freeman Road is the address.
Yes, sir. That's my address now. I have moved since she has passed. I moved back to her residence.
On
to-
January 1st, the ticket shows a Freeman Road address. You
That
didn't
was-
live there then?
No, sir. I
You-
did not.
So
I
you-
love, you can look back at all my other paperwork and it states on there, it was 1723 Virginia Street, Alford, Florida. That's where I resided.
So you were, where is Pike Pond Road? Where's that at?
Pipe Pond Road. It's all Alford
Not
area.
that much, but
It's
where?
7 miles south of Alford. It's on its way to Panama City.
The highway?
Yes, sir. No, it's a road off, it's a county road.
And you're going to the hospital at that time of day?
Yes, because they had
Okay.
called me about 5:30 that morning and told me we needed to talk about other arrangements.
Okay.
Because she was on a ventilator.
What was the charge you went to prison for?
DUI, possession, and actually, I had it looked up the other day when I started these payments, and they said it was a DUI and a possession charge, and that's what I went to prison on,
Possession of what?
methamphetamines.
All right, anything else you want to tell me or show me?
No, I just have her death certificate, and I have where I started the payment plan. Just now being able to work, I work at Compass Lake. I'm self-employed, but I paint boathouses and houses down there. And I can get around and make money because I have an e-bike right now that I'm getting back and forth on at the lake. And before then I had no way to get to a job, because I live in the country kind of.
What about the documentation that she was in the hospital? You got anything like that?
Yes, sir.
Can we see that?
The things that are highlighted on here are,
Just something showing she was in the hospital on January 1st would be helpful.
okay. Right here. And this is her insurance and where it was billed. The one that's in the blue at the top is the one with the day of that I had gotten pulled over. And that's where she was billed for her critical doctor.
When they pulled you over on this case, did they arrest you?
No, sir.
So they let you go into the hospital?
Yes, sir.
Okay. Anything else you want to tell us?
No, sir.
I'm not sure which prosecutor's handling this one. Mr. Mitchell, any questions for Ms. Kent, first of all?
No, Your Honor.
All right. Anything from the state? Are you through? I'm both. Oh, go ahead, Mr. McDaniel. Anything else, Mr. McDaniel? Anything from the state?
Your Honor, we'll just leave it up to your discretion in that situation, take into account her driving record and her priors, you know. We'll leave it up to the court. That's all I've got, Your Honor.
So I'm going out on a limb here. Well, I don't know. Most of the time, if she was sentenced to 6 months for driving license suspended, the state's offer would go up, not down, most of the time. That if she got one within next year or two. Were y'all aware that she had received 6 months?
At the time I made the offer, no, I just saw the prior. I didn't see what she had served.
You didn't go in there and look at it like I did to see what the sentence was?
Not intently at the time.
I understand.
I knew what it was, and I knew that if we were basically saying, hey, if you resolve that stuff in Washington County, then, you're gonna do this, but more than likely, I view it that way. Prison. It was a prison hold off. And so
The Washington County, the DOC sentence was out of Washington County. Okay.
yeah, I knew she was going to prison.
But I guess my question is, why was offer only, I understand with the offer being 60 days now that we know about the hospitalization, but why was offered 60 days before, if she got 6 months, year and a half before this, why would you lower it from 6 months to 60 days without knowing the hospitalization? That makes perfect sense. Looks like the state didn't look closely at your case, is what I'm saying, or they
Right.
wouldn't offer you 60 days.
Right.
But now that we know the whole story, the 60 days may be very reasonable. I don't know. It may be more appropriate or more in line. Normally, I would sentence you to 9 months or 8 months or 6, 7 months, something
sir.
more than 6. You follow me?
Yes, sir.
But there's a whole nother factor there that we've got to take into account, and that's the real life factor that your mother has passed away. So if I didn't have a license and my mom was in the hospital and they said, come, I would come, but I don't have 5 prior driving license suspended either. Do you live by yourself?
No, sir.
Who you live with?
I lived with my cousin at the time, but he works at the Sunstop and he wasn't able to take me. And plus, it was on New Year's Day.
Is there some tissues?
It was New Year's Day and no one was available. I tried to get someone to take me, but no one was available that day.
Okay. So, Mr. Mitchell, it complicates things greatly that with the hospitalization, from my perspective, what's your thoughts?
Typically, I'm in the same boat because we've seen situations like that at arraignments where, they have an excuse for driving. But
Let me see the
normally,
death certificate. I'm sorry, I didn't mean to interrupt you. Let me see the death certificate. Go ahead, Mr. Mitchell.
This is the big reason why we were contemplating, when she was contemplating on taking the trial because of exigent circumstances. I just don't know if that's an exigent circumstance.
It's not a legal defense, but it's a real world fact that a judge should consider that
And-
you were driving to the hospital and that in fact your mother passed away.
And Your Honor,
What day did she pass away?
she passed on the 5th, but it was signed on the 7th. Right here is the,
You're saying where it says date of death, January 7th is
Yeah.
wrong?
yes, sir, because right here I have, it's the way that they filed the paperwork. But I have
Wait,
on here.
you're
the
saying that
date.
her death certificate is wrong in the date?
Yes, I'm fixing to show you, on here.
Well, I saw where the insurance showed her being discharged on the
Sorry, it was
5th,
on the 5th. Yes, sir.
but the discharge date is not necessarily the date of death. Did she,
It's.
in your
the date
case,
she
it
passed.
is?
Yes, sir. My son is out here and he can tell you that's the day of death. I don't know why it was signed like that. And I didn't even notice that until I was on my way here going through paperwork, but
I'm trying to
yes,
see if it says on here that she was in the hospital. Sometimes the death certificate will say
yes, sir.
place of death.
I think it does say Sacred Heart on there.
It does. Facility name.
Yes,
Bay
sir.
Medical Center. So it appears from the death certificate, she was still in the hospital when she passed away, 69 years of age. All right. So, Mr. Mitchell, I think I interrupted you earlier. You want to say something else?
you pretty much filled in the blanks with what you said after that.
And,
That's
Your
nothing
Honor,
else from the state.
I think if it was me, if I had 5 priors or 10 priors or 20 priors and my mom, I'm assuming you got the phone call. I don't have any reason to doubt that. I think I would go. Whose vehicle were you driving?
I was driving hers. I have the registration right here of that too.
All right.
And I understand I have the priors, but I had just gotten out of prison for that. And I wasn't trying to, I was living in Alfred, so maybe I could get a job and get back and forth
You know,
without driving.
I'm sorry, I didn't mean to interrupt you. Go
No,
ahead.
it's fine.
You were saying something though?
Yeah, and I know that I shouldn't be behind the wheel.
Yeah, I can't. Mr. McDaniel? I can't put her in jail with her documentation she's provided. I think there's very little chance she's gonna make probation. I think I'm probably gonna put her in jail eventually, but I'll give her a shot at probation under these circumstances. I've accepted your plea of no contest. I'm going to judge you guilty of the offense. I usually don't do that on probation, but with her history, I'm going to do that. A judge you guilty of the offense. I'm going to sentence you to 11 months and 29 days probation, standard conditions of probation, plus the following special conditions: $400 court costs and fines. You will have a condition not to drive a motor vehicle unless you have a valid license. You will have a condition to obtain a valid license if one is reasonably available to you. No early termination of probation. If you violate probation, then I'm going to put a note in the system that your last sentence was 6 months in jail. So what that means is if you violate probation, there's a very good chance you're going to get more than 6 months. If you violate in a substantial manner, I'm not talking about missing one reporting period. I'm talking about disappearing on us, getting a new charge, something like that happens.
Yes, sir.
Then you are very likely to receive more than 6 months in jail if I'm still the judge at that time. Do you have any questions?
No, sir, thank you.
Ms. Kent, you're welcome. I do wish you the best. I'm sorry for the loss of your mother. I'm going to ask that you see Mr. Goodson with the probation office here,
Yes, sir.
and Mr. Goodson's going to give you some instructions. Mr. Mitchell, anything else? Mr. Bell, anything else in this case?
No, Your Honor.
Mr. McDaniel? All right, see Mr. Goodson, man. Wish you the best.
Thank you.
Yes, ma'am. Let me add.
Friends, I showed different judges for different reasons. And the reason why I consistently show Judge Mercer is, in my opinion, he is one of the most human that is out there. I think he looks at things from all sides. I've always been impressed, for example, by the fact that he involves family members who are in court and makes sure that they're heard and that their questions are answered. But in this case, it struck me, and I mentioned this in the chat, that he actually admitted if he had 5, 6 priors, wouldn't matter to him, he would have gone as well. That's somebody that's actually thinking through real world and what humans face, rather than just here's the book and get ready because I'm about to throw it at you. So good on him. He also said, look, I'm probably going to put you in jail at some point because I don't believe that you'll make it through probation. So he's honest, but you have to appreciate the fact that under those circumstances, he gave a chance. At least that's my thought. If you disagree, let me know in the chat. Let's head north slightly, and we'll check back in again with Judge Manning.
He's only had 1 dead battery on March 19th, for about 25 hours.
Number of arrests, 12, 15, 25.
Wait, Council, what do you say?
Your Honor, Anthony Peake for Mr. Hatcher on behalf of the Public Defender's Office. Looks like, Judge, that he cured that fairly quickly within the 24-hour period, once realizing that the charger was not charging it. Judge, it looks like he is due for removal on May 24th. We would ask the court to reset this at a time closer to that date to consider removing the ankle monitor if he stays in compliance.
Let me open up this. Mr. Jenkins, what do you say?
Your Honor, just keep up the good work, and we'll see you the next time we come into court.
It's been modified a couple times. I'm trying to keep up with what it is now. Oh, and it says for a job you can leave to. You have a job already?
I'm working on it now.
All right, so as long as you have a job or if you move, make sure you reach out Second Chance, let them know. Hey, I'm moving to this address, I'm working at this address, and this is my schedule, okay?
Okay.
And we'll keep it on, we'll put it up, we're gonna keep that on and I'll see you and we'll get you on the calendar, okay?
Yes, ma'am.
All right.
Go ahead. It should find me.
Right, Jack Henny. Twenty-five PI 00364. What do you got, second chance?
He's had 4 dead batteries within the past 60 days.
No new arrests, had it on 6/6/9/25.
All right. Go ahead, counsel.
Judge, I believe that he's remained in compliance other than the dead batteries. I have not heard that he's done anything else. He's not been at least caught where he's not supposed to be. Judge, this is compliance only. We're asking that the court allow him to remain on the ankle monitor under current conditions.
They can't remove it.
I'm sorry?
He can't remove it. Been on since last year.
Since you've only been on since.
It's almost a year.
Oh, Judge, he just informed me that he's been on this ankle monitor for 10 months now. And I'm looking at these orders and they do appear to be from June of 2025. I would ask the court to consider removing the ankle monitors.
His order predates the new order. So it does not have a 6-month termination.
All right, Mr. Jenkins.
Your Honor, for 4 dead batteries, we'll leave it in your discretion with these charges, and they are serious. And
So why the batteries go dead?
I be working like 12 hours, you go work, dead at work.
So when you got your ankle monitor, they tell you charging about an hour in the morning and an hour in the evening.
I charge it at night when
I think that we speak an hour in the morning and an hour in the evening, and that makes sure it keeps it completely charged.
okay.
Okay? Right, I'll put on this, we'll keep it on. And we'll sit you up for another compliance, okay?
All right, thank you.
All right.
Thank you.
And second
Let's
chance,
go.
Second chance.
do you have the new monitor here?
I do.
You do? Can you swap them?
Okay.
So
Just stick
so
around.
you can have a longer charge?
Okay, they'll swap you out for a brand new one, so it's.
Hey, Judge, I heard you listening.
I was waiting.
How are
you? Good, good. Hey, what about
speak. What's going on?
Jonah Sampson, 25 PI 001991. Jonah Sampson.
Jonas Sampson, come to court or your bond will be forfeited. Jonas Sampson.
Go ahead, counsel.
Your Honor, Anthony P. for Mr. Sampson, he appears to be a client of the Public Defender's Office. I cannot account for why he is not here. I do see a note on the calendar indicating that he may be in behavioral health treatment court. I do have a copy of an order from October of last year that shows he was released to accountability court staff or was to be released.
Yeah, to Judge Richardson, do you know anything, Mr. Jenkins?
I do not, Your Honor, and other than our usual announcement in connection with these matters subject to appropriate notice, in this case, they would request bench warrant bond forfeiture.
What we'll do is we'll check,
Yes.
see if he's still in the, with Judge Richardson in his counter, okay?
And Judge, my concern is that this order's from October. I know the accountability programs last a little while.
But not that long, right?
But, well, they do last a little longer than that, unless he's really doing well in it. And I just wanted to make sure, I would ask the court to consider resetting this matter because I'm not sure whether he would have gotten notice, whether he updated his address, if he is done with the behavioral health treatment court.
Well, that's what we'll do. I'm gonna check and see if Judge Richardson's handling it or what she wants me to do.
Yes, sir.
I promise I won't sign a bench warrant until I get the file.
Thank you, Your Honor.
Okay, Michael Brooks, 25 SC 005363.
Michael Brooks, come to court or your bond will be forfeited. Michael Brooks.
Mr. Pete, what do you got?
Your Honor, Anthony Pete for Michael Brooks for the Public Defender's Office. Judge, it looks like the last order I have was from April 16th, filed, and it looks like there's I don't see an ankle monitor requirement on it.
Release 10/18/25.
I do see a curfew.
Yeah, it says, on the front, it says order modified with electronic monitoring.
Yes, yes, so I do see it.
So, so what we think, because it looks like just a change of address was just submitted on the 17th. That was just unfiled by Ms. Eustace, so I don't know if this notice had a chance to get returned. So we'll check and see, we'll just reset it to that, okay, and check and see if it's been returned, but we'll keep that ankle monitor on. So make sure if he comes by, you guys will take it off, okay?
Yes, Judge, and I will make sure that Ms. Eustace knows. She said it's Ms. Eustace.
We'll just issue a new one to make sure it doesn't come off, okay?
Thank you.
All right, let's see, Jaquavius Avery, 25 SC 006719. What's the Avery? All right, what do you got, second chance?
We have no violation within the past 60 days.
What do you got?
No new arrests, 24, 25. He's having, he's on pretrial.
Who's your lawyer?
Judge, it indicates that a conflict attorney, Ms. Gibson, was the attorney at the time. I don't know if new conflict counsel has been appointed yet.
Go ahead, what?
I was trying to say, I play football in the season. We start back practicing next week. I was trying to see if would I be able to start practicing.
Start practicing, but you got the ankle monitor.
I know I still can play with the ankle monitor.
Practice with who are you playing? For?
Douglas High School.
Jenkins?
Your Honor, I don't, as long as he complies with the other terms and conditions of his bond in this matter and keep up the good work and compliance, certainly any school-related matters, we don't have an objection to.
All right, how about we do that? Well, when does it start?
April 27th.
That means 2 practice at home, okay? So you gotta let them know what time practice starts. How long does it take you to get from practice to your house?
Well, sometimes I be walking, so it probably take like 15 or 30 minutes, depends what time practicing at.
Okay, so let them know, you gotta let them know the practice schedule, okay?
Yes, ma'am.
Where it is and what time that's to, and if you're walking, let them know you walk.
Yes, ma'am.
All right, have a good one.
You too.
Go Astros.
Boy, in high school on an ankle monitor, and he still wants to play the foosball. I get it, but dude, you gotta get your life straight. Yeah. Anyways, let's go to Michigan. Judge Simpson just getting his day started.
Exists between this honorable court and the office of public defender. But if one were to arise, we would waive any claim that a conflict exists.
Your Honor, people do not believe that there is any conflict present as well. In the event that conflict were to arise, the people would similarly waive any such.
Court also does not believe there's a conflict either in the Michigan court rules. There are the cases decided there under. To the extent a conflict does exist, given the waivers, court will consent to hear plaintiffs. All right. Mr. Brown, we have a bond violation.
Yes, Your Honor, I've shared it with my client. He will admit that he tested late on the dates contained in the report from April 15th, authored by Community Corrections Supervising Agent Charles Mormon. I can give the court some background.
Go ahead.
Present here with his mother, who took her time out of her day to come see about her son. What was going on with him? He was working at, I believe it was Burger King on Stadium, Taco Bell on Stadium, and he worked 4 night shifts and 2 morning shifts, and his biological clock was thrown off by some of those hours. So for example, he'd get off work 3 or 4 in the morning, and then he was supposed to test between 4 a.m. and 7 a.m. and fall asleep but he'd wake up and then he'd test and his tests were negative for any controlled substance.
Why did
Now,
he test it? I mean, there's a 3-hour window.
you sleep after working a shift at kid, 24 years old, Your Honor.
But we had sent to him, I mean, there were times before this had the problem. And we had sent an order to comply to him back on March 9th, so not taking any action. And then he was good for about 10 days. And then proceeded to have 1, 2, 3, 4, 5, 6, 7, 8, 9. Test.
Missed, but they were compliant, no alcohol. If we're on page 2.
I understand there's no alcohol, but I could consider these violations. He's supposed to test in that time window.
And I've impressed that upon him, Your Honor. That's why he's here. Also, he's now left Taco Bell and he's at doing landscaping, and he's advised his agent. So they adjusted or tried to accommodate his work schedule, landscaping now. And I have his works.
How is that gonna work? Landscape. That could be even more problematic.
I talked to him about that, but he thinks that he's worked it out with his agent so that they now have a plan so that he's going to comply and test during the windows that you've ordered.
Anything from the people?
The court indicated the court is quite clear about the April retrial. There's not to be any more late tests, unless we've gotten us late tests. I think the best way forward is to frame tether. That way there can't be any late tests. We continue monitoring the defendant.
In his defense, Your Honor, he was seen by Mr. Statman and got his assessment on April 17th. So we are trying to move forward with the case. We're not dragging our feet, and I'm not changing the subject, but he got a new job and he's trying to do better. And he's got his mama here in court today. Ma'am?
Oh, I see her. All right.
Did I miss anything? Okay.
Only there was some time that he wasn't able to change the testing schedule when he switched jobs and switched schedules. I think that was an issue.
And ma'am, for the record, what's your name? Sarah Ladd?
Mother's Day is coming, Judge.
Am I supposed to do with that?
Mother's Day is coming. I mean, it says a lot. She's standing up for it.
I get that, but I mean, I've got 14 missed tests.
Yes, Your Honor, but no alcohol. She'll tell you he's not drinking.
Young man, when you got the order telling you to comply and no more late tests, and when I told you in court, no more late tests, what were you thinking?
To just try and get them on time. Try to not go for any more late ones, but sometimes I just lose track of time when I'm at work. Most of these have only occurred when I'm physically at work.
Young man, tell me why I shouldn't just throw you in jail? You don't listen to the court's order. That's 2 orders you haven't listened to. Yeah, the first order telling you to test, and then I sent you another order telling you to comply.
Well, I don't think I should be put in jail because I'm besides being late, I'm complying with everything else and doing exactly what I need to be doing. Not touching drinks, just working and doing what I need to do.
What about your association? Still hanging out with the same people you're drinking with?
No.
What I'm gonna do is, defendant having admitted to violations, I'm not gonna incarcerate you at this time yet. But, you're gonna go over to community corrections, just placed on the Graham tether. Any types of violations such as not being charged, not properly downloading, all of those things. If you don't follow that to a T, you're going. Am I understood? I didn't hear you. Thank you.
Yeah.
Do you have the unit with you?
Yeah.
You take that over and they'll fit you with the scram tether. Court does call the case reverse Connor Kearns. Oh,
Still separate.
it's already,
Okay.
yeah, this was a bond violation.
Bond violation. All right.
All right, let's hit pause just a second because I want to clear up some things. So my understanding is what he had was a SoberLink. The SoberLink is a handheld device that you have to blow into when it tells you to. And those were the tests he's missing. Now, again, that's handheld. Now, what he's going to go get, he's going to trade that in and get a scram tether. And that's what you're talking about in the chat, Barbara. That is the one that is an ankle bracelet that's continually monitoring your alcohol consumption via your perspiration. So because he can't seem to get it straight with the SoberLink, he's got to trade that in for the scram tether. So that's what's going on with that case, just so we're all clear. Let's get back to Judge.
Court does call the case reverse Connor Kearns.
Alexander, on behalf of the people, Your Honor.
Morning, Your Honor. Richard Blifford on behalf of defendant Mr. Kearns is here in the courtroom with me.
Your Honor, today's date and time for an emergency bond violation hearing. At this time, the defendant is going to acknowledge the allegations that are set forth in the complaint.
Bond violation.
Bond violation, correct.
Okay. Anything from the people?
Your Honor, I'll just rely on our previous motion. I do want to say, I did mention that there could be a potential for future charges. I do need to get a little bit of further investigation done before I make a final decision on that for both defendant and defendant's mother. They were both submitted on by Ann Arbor Police.
Who was?
Defendant and defendant's mother.
All right. Okay. Anything you want to say?
There are actually quite a bit I want to say, Your Honor. Defendant is the parent, is married to the victim in this case. There's a highly toxic and dysfunctional relationship with victim. The victim sought a PPO. There was never any allegation that there was striking, hitting, assaultive behavior in the PPO. There's more threatening behavior and things of that nature, but not like I've been punched or I've been hit or anything like that. In any event, the PPO was put into place earlier in the winter. The PPO obviously was at the choice of the victim. I'm just going to lay it out for you, Your Honor, and maybe in a way that's not helpful to my client, but I'm just gonna lay it out for you. These people have been in nonstop communication with each other since the day the PPO was granted. Hundreds and hundreds of text messages. I just looked at my client's cell phone log this morning before in the hallway before I came in here. Hundreds of text messages, including, Your Honor, more than 25 text messages yesterday. The parents have a child together. The child's birthday, his first birthday was on April 12th. The parents went to church together on April 12th for a birthday party for the child. They visited with the fire department and took the child on a ride in the fire truck together recently. The victim, I read through every one of these texts, and as an officer of the court, I could tell you that there is not a scintilla of evidence that indicates that the victim is scared of the defendant. The victim is asking the defendant to come and be part of her life. The defendant has Venmoed the victim thousands of dollars since the inception of the PPO. How does he Venmo her? She calls him and says that it's money, and he Venmos her money. The victim has shown up at the defendant's house. Defendant has been at the victim's house. It's a highly dysfunctional relationship. Some of the texts, Your Honor, that the victim has given I read this morning, some of the texts, the victim is advising the defendant on how to beat this case, on what strategies he needs to be using to beat this felony case against him. And so I'm making some admissions to the court that maybe under some circumstances would be against the best interests of my client, but I've been in front of you, Your Honor. I know you're a straight guy, and I think the court would rather hear this than some nonsense. That's been the relationship that's going on here. The defendant is 31 years old, Your Honor. He's a honorably discharged member of the United States Army, served in the airborne, served in Ukraine, served on the border of Syria. He receives an 80% disability payment through the Veterans Administration for some lower back issues as a result of parachuting. He has been enrolled at Washtenaw County Community College, and on May 6th, he's supposed to receive his associate's degree in transportation technology. So he's been involved in a 2-year program. He's supposed to graduate from that program in the next 2 weeks, Your Honor. He has final exams coming up in the next few days. Court can see his parents are here with him. They share with me, and the victim and the defendant shares with me that there is some counseling that he can get through the VA that would probably be appropriate. As an attorney, and I know you're an attorney, it's frustrating to me that the defendant has conducted himself in this way. I've shared my frustration with him about this. It's just very frustrating that I can't impress upon him or I haven't been able to as of yet, that I don't care if she shows up at your house. If she shows up at your house, you run in the house and lock the door. That's what you do. And that's how you handle it. And so there's been some monumental bad judgment here. In regards to this allegation of an ear tag being put in her car, the defendant says that took place at his house with the victim participating in this. So,
excuse me, that he and her did it, that they did it together?
He said that she came to his house unannounced in Ann Arbor, his parents' house where he lives. They discussed putting an ear tag in the car so he would know where her and his child is. And she said that would be a good idea. And the ear tag was placed in the car. And
That's true, then why does she have concerns when it alerts her phone?
because it's a highly toxic relationship, Your Honor. The parents are trying to evict the parents are in the process of evicting the victim from their condominium, where the former marital home, the parents are the owner of that home. They're in the process of evicting it. It's a cluster of incredible proportions that are happening here. The amount of legal fees in this case are eye-watering, Your Honor. And it's just, I think that I come here today asking that the defendant be given another chance. And I can't promise the court that he's going to be able to control himself to not communicate with this person. I think that this brings it to a level of seriousness that we haven't seen up until now. But I think that he deserves another chance. There's no allegation of physical.
Well, and maybe counsel, and I get that they've got a child together, there might be some conduct, although there shouldn't be.
Hundreds and hundreds.
Problem is, he's the one, I know you know this,
and
he's the one that cannot have that contact.
And I've told him that, his parents have told him that.
But what I don't get is I don't understand this air tag. That if they're having so much contact, why do I need an air tag?
Well, I mean, I could just tell you anecdotally, on my phone, I can see where my wife is at all times, and so.
I can do that without an air tag.
Yeah.
All she would have to do, share her location with him, and he would know.
Your Honor, all I can tell you is I'm seeing texts as early as this morning at 9 o'clock, at 8 o'clock this morning, texts from the victim saying, I'm going to the prosecutor's office because this is all a big misunderstanding. I'm not making that up. That's the text I see from the victim at 8 o'clock this morning. Okay. I saw the same text from the victim 3 times yesterday. She texts him that this is a terrible misunderstanding. And so the defendant is here. He's executed, he's demonstrated monumental bad judgment. We're here falling on our sword. We're not here trying to say that this didn't happen. I told my client, what are you gonna do? You're gonna come tell the judge you didn't do this? You're not gonna lie in court. And so we can't do that. That's not an option, to come to court and deny this. That's just not an option. It's not an option for me as an attorney. It's not an option for the defendant. And so there's just bad judgment here. I'm hoping the court could give him the proverbial second chance. I'm hoping that you could impress upon him the seriousness of this. But I'm asking you not to take him into custody, Your Honor. I just don't think it rises to that level.
Counsel, let me just say this. I hear what you're saying about the contact, and that shouldn't even be happening, and I'm sure you're after about that. It rises to a different level when I'm tracking your whereabouts. That's my problem.
The defendant tells me that this was done cooperatively between the parties. And
then, I heard you the first time regarding that, and I don't believe it. The reason I don't believe it is because he obviously hasn't been following the court's orders, but also the whole tenor of the police report, which I'm sure you got a copy of.
I did.
Doesn't indicate that this is anything cooperative on her part.
I know, but Your Honor, this is also somebody who went and sought a stalking charge and then went and contacted the person saying, this is the police understanding here. I never meant to see you charged like this. So you have a very frenetic victim here who is, on what day of the week, it's a toxic relationship. These people do not do a good job communicating with each other. So if for chance, she asks for a Venmo and it doesn't go through, guess what? She's off to the police department. I mean, that's the nature of this relationship. And that's something that needs to be resolved via the divorce. But I mean, this is an insane relationship here. And from what I gather, and I'm not a testifier, from what I gather, it doesn't rise to the level of striking each other or hitting each other in the face or that type of thing, But as far as, daggers out and just sort of crazy conduct, these people are involved in a spiral of crazy conduct with each other. They're both part of this crazy conduct, both of them. But you're right, Your Honor, the defendant is the one who's here in court. The victim is not in court. She's not on the court doesn't have jurisdiction over her conduct as to whether she shows up at his house. And so it's just been bad judgment. It's terrible judgment. And, that's, it's funny because, I thought long and hard about this weekend. What am I going to say to you? I really, belabored in my mind, what am I going to say to you? And this is what I'm going to say to you. And I think he deserves another chance. I do believe he can fly straight. And that's our prayer to the court, Your Honor.
So
I did also want to note in the court that our victim advocate did speak with the victim today, and I also spoke to the hallway. That's where I was before this, and I didn't have any mention of any of that, including the cooperative air tag on her part. I told her she can leave before this because she was not testifying. She wanted to leave. She didn't want to be present today in the courtroom, but she did not mention any of that. And I have not seen any of these texts either.
But she did not indicate that this was somehow cooperative or somehow
No, Your Honor.
that the police report itself was some type of misunderstanding.
No.
Did she indicate to you that the entirety of the case was a misunderstanding?
No, she informed me that, and I was just throwing, she wanted him to get out. And she was concerned about his parents and what was coming with that. So she just had concerns with what was going on.
There's a highly conflictual relationship between parents and the victim as well. It's off the charts, Your Honor. Mainly revolving an eviction.
How old's the child?
The child just turned 1 year old on April 12th. That's when.
This is the part that's phenomenal to me. I've got the parents at each other in some way. Well, I think somebody may have arrived. Sure. I've got the circumstance that the parents are at each other, the parents of the child are at each other, defendant, his wife are at each other. There's a divorce going on. There's then this stalking case going on. There's then going to be, thank goodness the premises, I think, are in Ann Arbor, so it's not my jurisdiction. There's then going to be an eviction that's going on, which makes no sense to me. Everybody keeps raising this to whatever level. The other concern that I have is, and counsel, I get what you're saying to me. Trust me, I do.
Thank you, Your Honor.
And I get the notion of periodically through the weekend after I'd seen the motion, I'm trying to figure out what was he gonna tell me after I went through and read the police report and everything, and I don't want to necessarily escalate it, but I'm having a difficult time believing with everybody operating with iPhones that the purpose of that tag was as you said it was. She's here. If you want me to put her under oath, and then I'll figure it out that way. But if I get that clients tell attorneys things, and I get that then the attorney has to come up and you have to say what the client's telling you. I get all of that. I'm telling you, that notion of why that tag's there doesn't fit with anything I see in the police report. Doesn't fit, and maybe in certain relationships doesn't fit with any common sense I know of, but that can happen. But it doesn't make any sense. And now that she's here and Miss Linda, I'm presuming available to testify before the court if necessary.
Yes, but if that were the case, I would ask to briefly pass it so she could speak with my victim advocate. And
Understood. I don't know. Well, hold on a second. I don't know if your client wants to change his position on what he's had laid to this court about that air tag.
If we could pass the matter, and I would say to the court that we're not necessarily sharing testimony today. But
Oh, I know, and I'm not, and understand that
but
let me just say this. I look stupid, but I'm not. And the problem is that I realize your client has said that to you, you've related to the court. I don't doubt with regard to any contact that you told him what you said you told me. I don't doubt any of that. I'm just having a real tough time believing your client's premise for why that's. And I'm sure, because you have been before me, and one of the things, the worst thing is, if you lie to me, we're gonna have a whole other set of problems.
understood, Your Honor.
So what I will do, knowing that she's here and that I may take testimony, I'll pass the matter. So that the victim's advocate can talk with her, you can talk with your client, and then somebody wants to give me a story that makes some sense, fine. All right? He is to remain in the building, it's not to leave.
Of course,
All right. All right. Is that all I've got for 11? And why is he here yelling at me then? He's over there screaming at me, Judge, get moving. I'm sorry, that's what I heard. I don't know. Court's gonna stay in recess.
All rise.
All right, friends, hour 4 now of TCF Live. Nice to have you all with me. So I'm going to keep an eye on Judge Simpson's court, and if they come back here in the final hour, we'll go back to that. Worst case scenario, I'll try to capture it, and maybe we can pick it up tomorrow. But so I don't know if y'all used to read Shakespeare or currently do, but Hamlet tells Ophelia at one point to, quote, "Get thee to a nunnery." And he was basically telling her that out of the idea of protection. But at least that's what I thought. But now I'm going to take you to Judge Prill's court, where the defendant is named Jeffrey Shane Nunnery. So perhaps what he was suggesting to Ophelia was that he had a guy for her. I don't know. Let's see what this guy's all about.
Around the record, people of the state of Michigan versus Jeffrey Shane Nunnery. 4 files, 25, 73, 54, 55, 56, and 57 FH. Time and date set for pre-trial. The defendant is present, represented by attorney Elizabeth B. Weisenbach. People are represented by prosecuting attorney Timothy J. Rakowski. Court is in receipt of an amended information that's been filed in this case relative to the 7354 file. Ms. Weisenbach, have you received a copy of that document and gone over it with the client?
Yes,
Did you waive the reading as well?
we do.
It appears that there may be a plea agreement here relative to all of this.
Yes.
All right. Mr. Nunnery, please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do. Thank you. Mr. Rakowski, would you please state the terms of the plea offer on the record?
Well, may I have a moment, Your Honor?
Sure.
There was an email, Your Honor, I sent for a package offer. I was trying to find out mine. Why it's not clean.
Okay, yeah, that's fine.
We'll look for it. Your Honor, the plea offer is to resolve all these files that were in front of the court. By doing so, going to resolve itself in the following, Your Honor. Mr. Nunnery would be pleading to a single count of continuing a criminal enterprise, and that would be in file 25-307354FH, and being habitual offender third offense. People would agree to dismiss the other charges. Mr. Nunnery agrees to pay full restitution on all these matters, whether charged or uncharged, and whether the case resolves in a separate conviction, regardless of whether that is a conviction or not. These other matters also would be included for potentially restitution. We agree not to proceed on any further habitual offender notice. Mr. Nunnery agrees to forfeit all the firearms recovered and seized by law enforcement for disposition to the seizing agency. And the people also agree not to proceed on a new Michigan State Police report involving another track.
Ms. Weisenbach, is that your understanding of the plea offer?
It is. I just want to clarify, charged and uncharged. There are 4 cases charged here. The uncharged that I have received a Michigan State Police reports, incident number 31511625 is the only uncharged that I am aware of. I would ask the court to limit it to that one uncharged. I do not have any others.
That's what we've supplied to Ms. Weisenbach. That's all we had.
All right.
So that ends up being 5 matters, but that closes that. It's not ongoingly open. Other things we would have to have a conversation about.
Do you agree, Mr. Rakowski?
I agree, but some of the information from one of these files is not in the, I believe, the plea packet that I put together for the court. So as long as we're on the same page, of anything out of these 3 files potentially be restitution. And once again, it's not something that they couldn't have a restitution hearing on if there's some dispute to it.
You're okay with that, Ms. Weisenbach?
Yes.
Okay. Mr. Nunnery, did you hear the terms of the plea offer outlined a moment ago?
Yes, Your Honor.
Is that your understanding of the plea offer?
Yes, Your Honor.
And you wish to accept it?
Yes, Your Honor.
Are there any other terms to the plea offer that we've not covered on this record?
No, Your Honor.
Ms. Weisenbach, do you agree?
Yes.
And Mr. Rakowski?
I agree, Your Honor.
Thank you. Mr. Nunnery, are you on any term of probation or parole? No, Your Honor. Have you had sufficient time to speak to Ms. Weisenbach? Yes, Your Honor. Do you need any additional time to speak with her? No, Your Honor. And is there anything affecting your mind or brain making it difficult to make important decisions? No, Your Honor. You have a clear mind? Yes, Your Honor. Mr. Nunnery, pursuant to the plea offer, you'd be pleading to conducting a criminal enterprise, habitual offender third. That is a felony, carries a maximum prison sentence of up to 40 years and or a fine of up to $100,000, criminal forfeiture of proceeds, substitute of proceeds, instrumentalities of any racketeering. Court can also order court cost of investigation, and cost of prosecution. You understand the charge and maximum sentence that can be imposed? Yes, Your Honor. I understand the charge as well. Yes, Your Honor. Understanding that Ms. Weisenbach, how did your client plead to this amended charge on or about October 6, 2025 in Rubicon Township, Huron County, Michigan?
No contest.
Is your plea no contest, sir? Yes, Your Honor. Reason for the no contest, Ms. Weisenbach?
Potential for civil liability, Your Honor.
Any objection, Mr. Witkowski? No objection, Your Honor. That is a proper basis. Court shall proceed in that fashion. Ms. Weisenbach, have you gone over an advice of rights form with your client?
We did.
Mr. Witkowski, you can continue. Thank you, Your Honor. Court is in receipt of an advice of rights form listing all the files on it, has a signature on it dated April 19th, which is yesterday, and a printed name of Jeffrey S. Nunnery. Did you sign this document? Yes, Your Honor. Now, before signing it, did you read it over? Yes, Your Honor. Did you also go over it with Ms. Weisenbach? Yes, Your Honor. Do you understand the rights contained on the form? Yes, Your Honor. By entering a no contest plea, you're giving up those rights. Yes, Your Honor. Means you will not have a trial of any kind, nor have any opportunity whatsoever to contest your guilt. The no contest plea is tantamount to admitting your guilt, and all that remains after today will be for you to be sentenced. Yes, Your Honor. If this plea is accepted, you'll be giving up any claim that this plea is a result of any promises or threats not disclosed to this court during this plea proceeding. And you'll also be giving up any claim this plea is not of your own free choice. You understand? I understand, Your Honor. Other than the terms of the plea offer outlined on the record, has anyone promised you anything such as leniency to get you to plead no contest? No, Your Honor. You understand that no one can make any promises for the court as to how the court will dispose of this case. That is, no one can promise that the court will be easy on you in imposing sentence. Do you understand that? I understand, Your Honor. Does anyone promise the court will be easy on you? No, Your Honor. Does anyone threaten you to enter this plea? No, Your Honor. Is this plea your own free choice? Yes, Your Honor. Court costs are due and payable at time of sentencing unless there's good cause shown. Are you aware of that? Yes, Your Honor. And that you're subject to a 20% late penalty for any unpaid monetary obligation due 56 days following a conviction and sentence. Are you aware of that? Yes, Your Honor. Finally, if this plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeals from the convictions and sentences pursuant to this plea, actually sentences, would be by leave to appeal to the Court of Appeals and not by right. Do you understand that? I understand, Your Honor. In other words, you don't have an automatic right to appeal. It'd be by leave to the court. I understand, Your Honor. All right. Again, any questions of Ms. Weisenbach? No, Your Honor. Any questions of the court relative to any rights? No, Your Honor. Okay. Court is in receipt of People's Proposed Exhibit 1, which is a Sequing Police Department Incident Report 25-488. Ms. Weisenbach, any objection to the court considering this for a factual basis?
No, Your Honor. There's actually three there.
Are there three? Okay. Oh, I see. Yeah, there are additional reports here. All right. Court will admit one for purposes of factual basis only. Mr. Nunnery, do you acknowledge being previously convicted on June 8th, 2004 in the 34th Circuit Court of Roscommon County for breaking and entering a building?
Yes, Your Honor.
Do you also acknowledge being previously convicted on June 28, 2007 in the Oakland County Circuit Court, 6th Circuit Court, home invasion in the 2nd degree?
Yes, Your Honor.
And on the same day, June 28, 2007, convicted in the same court of burglar tools possession?
Yes, Your Honor.
And finally, in 1995, October 24, 1995, you acknowledge being previously convicted of burglary of a dwelling in Washtenaw County Circuit Court. I'm sorry, Washington County, state of Florida.
Yes, Your Honor.
So this is at least your third felony conviction. Would you agree?
Yes, Your Honor.
Okay. Mr. Rakowski, you aware of any promises, threats, or inducements to this plea other than what's been disclosed?
No, Your Honor.
Ms. Weisenbach?
Agreed.
Has the court complied with the court rule concerning pleas, Mr. Rakowski?
Yes, Your Honor.
Ms. Weisenbach?
Yes.
Mr. Nunnery, there's no agreement made by this court concerning the plea and what the final sentence will be. Is that accurate?
That's accurate, Your Honor.
Ms. Weisenbach?
Yes.
Mr. Rakowski?
Yes, Your Honor.
Court will accept the plea. It's done freely. It's voluntary and understanding. Court accepts the plea also under People versus Lefebvre. The courts had the opportunity to review People's Exhibit number 1, and based upon that, and in the information, the court finds that the plea will not only factual basis is there to the original charge, but it also establishes guilt beyond a reasonable doubt. So the court will accept the plea and schedule sentencing for the same day as Weisenbach. Are you here that day as well?
Yes.
All right, that's awesome. Sentencing June 22nd, 2026 at 9 a.m. Prior to sentencing, the court is ordering a pre-sentence investigation report to be prepared, provided both counsel and the court at least 2 days prior to sentencing. Sentencing guidelines shall be scored and provided to counsel no later than 14 days from sentencing. Any objection or written response must be filed within 7 days of sentencing. Also noticed to the probation department. Mr. Nunnery must appear in the courtroom at the time of sentencing. If there's any supporting documentation by either party, must be submitted to the court no later than 7 days from sentencing. Any objection or written response must be filed 3 days thereafter. Bond was set previously in each of the respective files as follows: $25,000 cash surety, second file $10,000 cash surety, third file $50,000 10%, and fourth file $50,000 10%. Mr. Rakowski, your position on bond.
We have no objection to continuing bond.
Ms. Weisenbach.
Objection to that, I'm asking for it to cancel it.
The objection to cancel.
No, Your Honor.
Bond is canceled. June
for an hour. Got what, about 35 or so minutes to go. I have my eye on Judge Simpson's court. Both lawyers retreated back to chambers with Judge, so we'll see what's going on there. Regarding this guy, I don't think, now that we know kind of his background, that this was the nunnery that Hamlet was suggesting to Ophelia in Act 3 of that play. But now we know. Let's stay in Michigan. Let's go back to Judge Elmore. Looks like Colonel Sanders has a new contestant.
Thank you. All right. Also before us this morning is Mr. Kevin Stapleton. He's the agent from the Michigan Department of Corrections, who's prepared today's pre-sentence investigation report. We're here today for sentencing after the acceptance of 2 pleas back on March 6th of this year. Count 1 was for possession of the controlled substance methamphetamine, and count 2 was breaking and entering without owner's permission. That one is a misdemeanor. Let's see if we have any corrections. Ms. Dahl, do the people have any amendments, corrections, or objections to make to the contents of the report?
Yes, Your Honor, page 1 of CFJ 145. Under personal history and substance abuse history with methamphetamine, it says December 2024 through August 6, 2024.
Yeah, thank
I
you.
think that's a typo.
Yeah.
I'm not sure what the
You
correct.
know what that date is? The start date, Mr. Harrison, obviously can't be after the end date.
Correct. We believe it should be August of the following year. I thought that had been corrected. I apologize.
So really what we're doing is we're correcting the end date, which would be 2025, which. Got it? All right, thank you. All right, Ms. Dole, anything else?
Defendant's description of offense under CFJ 284A, I believe it describes a different offense than the current offense. So I know the PSI was speaking from another PSI that's done in Genesee County,
Yeah.
but I think that part does not apply to this offense.
All right. Mr. Stapleton, did you receive more than one statement from the defendant?
I just received the one written statement.
And that is probably a product of Mr. O'Rourke's inability to distinguish between the 2 cases. Because Betsy recites there are intended to the matter of Genesee County.
Mr. Stapleton, let's just go ahead and put a note there that says something to that effect, that the defendant, this information, the court recognizes that this information applies to another offense in Genesee County and not the pending charges.
Okay.
We'll just do that. All right, anything else, Ms. Dahl?
No, Your Honor.
Mr. Harrison, how about you, sir?
No, my cover was completely stolen.
All right. Okay. Allocution and Mr. Oh, wait, hold on. I don't see anybody here, obviously, but for the record, there's no victim impact statement coming in as they had for the count.
Correct.
All right, Mr. Harrison, now the floor is yours.
Well, one of the elephant in the room here is that this sentence is designed to be concurrent with the sentence in Genesee County. And the sentence in Genesee County will not be imposed until this afternoon. So we don't know what that is. Here's what we do know. He was convicted of a B grid offense, delivery in Genesee County. And at that time, although the 25 points for this conviction would not have applied, he was still, I believe, over the maximum for PRVs, even on that charge. I didn't realize it at the time because we took great pains to make sure that that was, we protected him as much as we could. So in all likelihood, and it's further his understanding that there will be at least a 36-month sentence handed down in Genesee. That's not terribly important because of the fact that he is also maxed out on PRVs here, the saving grace being a
simple possession. I know there's no such thing as a simple possession, but I use the term purposely to denote that it is typically the case. There are no offense variables applicable to this matter. So he's 10 to 23 here. The department's recommendation is for a prison sentence of some indeterminate length, leaving that up to the court, presumably to apply the guidelines to this matter. A further consideration that I would have you consider is the fact that Mr. O'Rourke believes he will be eligible for boot camp after serving approximately a year and a few months of his Genesee sentence. And he will be below 36 on this sentence ideally as well. That leaves that door open to him. Whether at the end of the day that is in fact the case is up to the MDOC and presumably the judge in Genesee County and you as well at some future date. That's something else that I'd like to throw into the mix here. Now, let's talk about this case as a whole, following as it did on the heels of the situation in Genesee County. He's clearly at this juncture of his life, he's out of control. He's making incredibly poor decisions, such as attempting to force his way into an apartment because of a relationship with someone who lived inside, a lack of understanding when the police confront him, et cetera, et cetera, et cetera. It all points to someone with a problem, and he does. He has a problem. I'm encouraged by the fact that I've gotten to know him. This case has been pending for a while, as you can see. I've kept in regular contact with him, and I've been pleasantly surprised at his burgeoning self-awareness and frankly, a rather mature perspective on this that A, I don't often encounter, and B, I didn't get from him when I first met him. So a switch has been clicked and something is in play here that I think is a positive direction. And we can only hope that the treatment and the counseling, et cetera, that they offer through the prison sentence will be and will continue his state of mind in conjunction with all of those other things. I think he can come out of this with a new lease on life. I would encourage the court to stay within the guidelines. I would simply say I don't see any reason to go anywhere close to the top of the guidelines, especially in light of the fact that we can take it as almost a guarantee that there's going to be a prison commitment on the Genesee case, and we believe that prison commitment will be in excess of 36 months. Thank you.
Thank you, Ms. Dahl.
Your Honor, I believe a prison sentence between 13 and 23 months is appropriate in this case. I agree with the defense that Mr. O'Rourke is on a very bad path. Made some terrible decisions and they caught up to him. Now he's going to have to deal with the consequences of that, and I'm hoping this is the low part of his life where he decides to take advantage of the resources in the prison system and go in another direction. But I believe a prison sentence is appropriate in this case. Thank you.
All right. Mr. O'Rourke, you have the right to make a statement. Is there anything you wish to say today, sir?
Other than like, I've just been going through a like really rough time. Well, mostly with the substance abuse and, like I just, it's just been a rough patch in my life. Just living like at home. It was just me taking care of my daughter and my mom. My daughter's mom took off on us, and it was really rough there for a while. And then I ended up getting in with like the wrong crowd, and then everything spiraled. And yeah, no, I'm just hoping to do some treatment when I get into prison, and hopefully that works something out. So when I do, get released, I can now go down a different path.
How is that you're bouncing between Cadillac and Grand Blanc and Burton and Gaylord?
Gaylord, I lived there in like I think it was 2012 to like 2019.
Mhm.
And then I moved back to Flint because that was the only place I had to go after my house burned down. And like I was living in Burton, but like my case, like Burton is right on the edge of Flint. So it was like I walk a block over and I was in Flint. And then during that time when I was using methamphetamine and I was on like just drugs, I got some retail frauds, so stealing for my habit. And, yeah, but everything kind of just spiraled. It was just a snowball effect.
Okay. All right, well, let's take a look here. We'll talk first about prior criminal history. There have been a couple periods, 2015 and 2025, when the wheels fell off for the defendant. 2015, he had a MDOP. Then while on bond for that, he picked up four cases. Looks like 3 were dismissed as part of a plea to one of them. That was the one that had the highest amount of restitution, which it was $18,000. Those were all property crimes. Of course, I can't consider those that were dismissed, but I can say he had a rough year, and looks like 3 again were dismissed for a plea, and the one that had the highest amount of damage. Then later that year, while on probation for that one conviction, he picked up another charge up in Seagull County. He did successfully complete probation. And then he made it 6 years. In 2023, he had another MDOP, which appears to be his go-to offense. Then shortly after that, about 6 months later, after getting off of the case in 2023, he picked up the operative intoxicated in 2024. He was on probation beginning August 9th of 2024. He made it about 5 months before violating probation and getting picked up for a delivery charge. And that one is one of those which is pending. At the same time, he picks up another case while violating probation. By the way, that last one I mentioned was in the 7th Circuit Court. Then he picks up this one in a district court, looks like over in Burton. That's a violation of probation. Then he picks up another one again. This one is over in Burton. And that's a retail, he had 2 retail frauds on the same date in the same town, in the same court. Then he picks up another case while on probation. And this one is in Grand Blanc Township. So again, that's the 7th Circuit Court. And there's a list of weapons charges. And then he violates probation again, picks up yet, I think it's the third pending case over in the same Seventh Circuit Court. That one was for more crimes of dishonesty, larceny, stuff like that. And then he picks up this case while on bond. So we definitely got some issues of complying with bond conditions, probation conditions. And when the wheels come off, he becomes a danger to himself and to others and their property. Now, I will note that, I'm sorry, the defendant also scores 105 PRV points. That's 30 more than the maximum under PRVF. And, that's quite excessive. I will note also, this is a part for judges, I don't know exactly how to handle it. Sometimes I involve myself a bit more, maybe I shouldn't, I don't really know if it's judicial overreach. So I'm not going to score it. I think he should have been scored 10 points for full V19. He resisted arrest, took off and fled. Oh, had that happened and had somebody argued that to me instead of scoring the 1 point, taking that and scoring it for 1 point for OV12, which would have been, which is still fine. But if you give me the 10 points for OV19, he bumps down to a presumptive prison sentence of 19 to 38. But I really don't know how I should deal with that. But I'm not going to, I'll just leave it there. I can also then conclude that the guidelines are inadequately scored in a situation, because even according to the guideline, I think you should be looking at a range of 19 to 38 points. So the defendant, wheels go off, they go way off. By the way, his blood alcohol level was a 0.194. That was just a PBT, but definitely there could have been drunk and disorderly conduct as well. So again, the guidelines, I don't think are adequately scored or even fully correctly scored. And I don't need to find reasonable grounds, but by the way, this is what happens is I'm going to get looked at by the state of how often do I give somebody a prison sentence when there's a straddle cell. They will use that to determine whether or not we get certain funding. But at the same time, I don't know if I should be doing overreach by telling you all how to score the guidelines and tell you that, at least for the people, had they even asked for, which we're not going to go back and do it, had they asked for 10 points, it would have been bumped to a presumptive prison sentence. And then I know what you guys don't care about, but I sure as heck do. If I sentence a straddle cell person to prison, it will be used against the court later on for budgets. But that's okay. I don't really care. I don't need a job based upon a budget. The court finds that that a reasonable proportionate sentence consistent on all the factors that I've talked about is as follows. The court sentences the defendant to a prison term, and I'm just going to do 20 to 120 months. Had anybody run all the guidelines and gone through and scored them, it probably would have been a year longer, but we'll leave it at that because I can't really tell you all how to do the job. And that's 143 days of credit. That will run concurrent with whatever other sentences he gets. There is a $68 state minimum fee for the felony, a $50 state minimum fee for the misdemeanor. By the way, Madam Clerk, for the misdemeanor, just 93 days with 143 days of credit. Actually, we're going to take it back 90 days. It wasn't 93, 90. $130 crime victims' right fund fee. I'm not going to assess any court costs or attorney fees or fines because the defendant's going to be in prison. I don't need any I find that the sentence is reasonable and proportionate, again, for all the factors that I've discussed today on the record. Anything further, Mr. Stapleton?
No, Your Honor, thank you.
Ms. Dahl?
No, Your Honor.
And Mr. Harrison?
Nothing further, Your Honor.
All right, Mr. O'Rourke, Mr. Harrison's going to bring you 2 copies of one document. You're going to place your initials on one copy. Doing so will neither elect nor waive any right. It merely acknowledges your receipt of your copy of that document. Now, this document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon of the plea in this case, any appeal must be done by filing an application for leave to appeal. Now, if you choose to file an application for leave to appeal and you want to appoint an attorney to assist you, you may complete the bottom half of that document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of that document. Do you have any questions, sir?
No.
All right. Anything else, Ms. Dahl?
No, Your Honor.
Mr. Stapleton?
No, Your Honor.
And Mr. Harrison?
Nothing for you, Your Honor. Thank you.
Thank you. We are adjourned.
Yeah.
All right, friends, let's get back to Judge Simpson's court. Looks like they're ready to pick up where they left off there.
Sure.
And then people, Your Honor.
This time the defendant is offering a no contest plea to the allegation, that being that he's able to articulate the facts, and we would stipulate to the police report as a basis.
Anything else from the people? This time, this is currently set for the ETC, I think this Thursday. So we'll continue the matter to the probable cause conference this Thursday at, was it 23rd? April 23rd, 2026, 9 a.m. At this time, given the admission to the, or the no contest, but admission to the violation, the defendant's bond at this time is revoked. Defendant is remanded.
Thank you, Your Honor. Thank you again for your time.
Thank you, Your Honor.
Alrighty, so it sounds like we pick that up on Thursday, if I heard that right. And in the meantime, he's gonna go sit in a jail cell. So hopefully we'll be able to follow up with that later this week. Let's go to Judge Prill, and we'll probably finish our day there, but I'm intrigued by this because this case is entitled Paul Clinton Barron II versus the Secretary of State of Michigan. So he is the plaintiff against the state of Michigan. I'm curious. So let's see what's going on there.
106065 AL. Mr. Barron is present. He is in pro se, pro per. Sir, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
The people are represented by prosecuting attorney Timothy J. Rutkowski. Sir, your name is Paul Clinton Barron II?
Yes, it is.
Okay. You filed a petition for restoration of driving privileges, correct?
I filed for the petition about a year ago. I've been dealing with quite a few different lawyers, paid for a lawyer who successfully graduated to become a judge. But in the process, I was, along with other people, couldn't be represented anymore. So I get handed a thing, go talk to this other lawyer. The other lawyer couldn't represent me. He was in trials and whatnot. I've done all the paperwork, everything that everybody needed, not more than one time, okay, because of mistakes in other people's paperwork, which has cost me more money than it's worth. 30 years ago, I made this bad decision, bad mistakes. In the 30 years without a license, I've struggled. I now have a child that's severely autistic that I have to take care of all day long. This guy that I spoke with through the state was very obnoxious, very, you don't have to treat a person like it's dirt because he's made mistakes years prior. Okay, I've done it.
Someone at the Secretary of State's office.
So the officer that I spoke to when I had the hearing, he was very obnoxious.
Is that Medelsky?
Yeah, he's very obnoxious in the whole situation. Now I've sent up there and he's trying to say about the transcripts. First off, they said they didn't even get my paperwork, which they signed twice that they received, but he said he never received, which held up my court hearings. Okay, now he's telling me he doesn't have transcripts. what am I supposed to, I get caught in the middle. I can't afford a lawyer. I'm busy taking care of a son on a fixed retired income. I've taken care of people all my life and struggled because of my mistakes of getting behind the wheel and driving numerous times.
Well, Mr. Barron, let me stop you for a moment.
But I
The court-
feel like I'm being, how can you say, well, here, let's add some more on them, add some more, being punished for this stuff, more so than anything else.
Okay, well, just to be clear here, Mr. Barron, the court is not looking at it this way. The court is only looking at it from what the documents are in the file. And as I understand it, you can correct me if I'm wrong, you did have some sort of hearing with the hearing officer.
Yes.
This would be hearing officer Medelsky. After the hearing was held, it appeared, tell me if I'm wrong, that they ordered you to be able to operate a motor vehicle, but with an ignition interlock device.
Well, with the ignition interlock device, for one, which I cannot afford, okay, to continuously spell out, because like I said, I have a whole family that I'm taking care of, a severely autistic son. Okay, that it costs money that, you know, where you're gonna pull it out. Okay, for another, he wanted something like set between 7 in the morning till 9 at night. How am I supposed to do things?
Okay, but to answer my question though, you were given a restricted license with that ignition.
If you want to call it a restricted license, all they said was to go back in front, go back and, get your driver's license, get this all on, come back in front of me in a year's time so that you can go back and, with the drug tests and all these pay more money.
Okay.
Come on, enough's enough. I've already paid thousands of dollars because one doesn't accept one drug test, one doesn't accept this, one doesn't, it seems like nobody, I'm trying to get my stuff straight, but nobody else seems to want to coincide either.
All right.
But now you're wanting to put me on this restriction, okay, and punish me more?
But just to be clear though, you wish to appeal the decision of the hearing
Yes.
officer.
Well, that's all I'm asking. I feel myself.
What is that? I just need to answer my question though. I mean, no disrespect.
No disrespect, but you also.
But you want to appeal the decision of the hearing officer to hopefully get a full driver's license.
Yes,
correct?
sir. Considering I've done everything not once but twice as far as rehabs and everything else on my own. Not, it's not being forced or anything. I've proven, okay, that I can rectify what mistake I made.
Okay, but just hold on a second. I mean, no disrespect.
You're not disrespecting me, sir.
And I appreciate that because I'm really not trying to. The thing, what I'm telling you is you have a right to have a hearing here in this court to challenge it. And I cannot render legal advice, just like Mr. Rutkowski cannot render legal advice. But when it comes to something like this, when the court receives a petition to have a hearing officer's decision reviewed, the court has to have not only the order, which you did provide, there's an order in the file, but there's also a transcript of the entire hearing, which the court has to review to determine whether or not you met one of the statutory requirements to warrant a changing of your driving group.
Well, see, they never gave me anything as far as anything to, I took everything upon myself as to what needed to be done and what not. Now, just like when I petitioned them to come down here, okay, they said they didn't get it. How can you not get it when you signed for it? That's not once, but twice. And I'm sorry, but my opinion is now turned into a game where here, send you there. Who's collecting this? Okay.
And that I don't know, because that's Article 1 under the Constitution. This is Article 3. The courts are completely different and distinct from the Secretary of State's office. This is the only thing I can tell you, and I know it's not what you want to hear, but I have to tell you, I can't render legal advice. However, I would strongly encourage you speak to someone who can help you with this. Number one, that likely an attorney. And I know the money's tight, I get that. But I can't tell
It
you.
is tight when you have one that turns around and you spend all the money, you've been in there for a year with this person and all of a sudden they graduate up to a higher step and everybody else gets left with their pants down.
And I can't speak.
And that's
to
what
that,
it's-
sir. I'm just speaking for myself. I would strongly encourage you to speak with,
And I refrain from using people's names or whatever because,
and I'm not asking for any names.
you know, I'm sure people know what I'm speaking of. and-
But I, as a judge, I can't, I mean, here's another example. Let's say, God forbid, one of my family members gets charged with a crime or has issues with the Secretary of State trying to get a license. I can't even represent them. I can't even give them legal
Conflict
advice.
of interest, yeah.
Right, but the same applies here as well. So all I can tell you is, sure, the petition's been filed, but the court needs additional documentation from the Secretary of State.
Should I have received this transcript or anything else considering?
I have no idea what
Okay,
the
because
attorney may have filed.
they're talking transcripts, you're looking at 30 years that have gone by, okay? And you're asking for a transcript of what, whether it was, what had happened 30 years ago or?
The hearing that you had, that the hearing officer.
Okay, so there should be no reason, that's not on my end. I never received anything either, except for near the last minute of, oh, now you got all these restrictions.
Mr. Rakowski?
I was just gonna say that what the court had indicated further is that if the judge just listened to you today, Mr. Barron, and decided to give you a license because we didn't have the transcript of documentation, the Secretary of State would appeal it immediately, and it would be, we're right back in the same.
And there
boat. That's
again,
why.
they're an outside entity, that's.
Sure. But with that, that's why the court needs those documents before it can go forward.
Well, can the court or somebody order these? Because it seems like every time I've tried to speak with this man, it's been nothing but problems with this guy. Okay,
The court cannot order it.
well, how, well,
I'm sorry, and again,
I know you can't give me any information.
I'm tied here because I can only hear what's contained within the transcript. But this is what the court is going to do. I don't want you to lose the opportunity of having the petition filed. In other words, well, the court's just going to dismiss it, then you're going to have to go through the whole rigmarole again. Court's not going to do that. I'm going to adjourn this matter for 60 days. 60 days from now, hopefully we have a transcript by then. If we have a transcript earlier, we can even schedule it earlier to have it here. But we need to have the documentation so we can proceed accordingly. But I'm not going to dismiss the petition because right now we don't have the documentation. I want to give you that opportunity to try.
I
to get it.
appreciate that because like I said, I've been battling this for quite a while. I've been denied 3 times because of lack of paperwork. Okay, which I didn't know how to do half of the stuff, so I can understand that. I had a lawyer almost 20 years ago go to try to represent me to see if we could, I got some sort of restrictions to come back and say, well, you owe me $250 out of 500, there's nothing we can do. Okay, and it's just been an ongoing situation where I've been bouncing around bad acts and everything else. This one wants this type of drug test, this one don't want it from this place, but this place can turn around and evaluate you, but they can't do your drug test. You know, it's been to the point where you feel like you just want to get in the car and say, here's your reason. Because
It's just like walking through that wall, sir. I get it.
you know,
I get it.
I'm saying,
I get it.
I'm not
That's why I'm
asking-
gonna give you the 60 days.
I'm not asking for, my hands to be tapped or anything. I served 30 years without a license and struggled. And I went to,
Hold
you know,
on. That's why when we have the hearing, I cannot consider anything outside the hearing. So that's why you can't expand the record. That's why I have to stop you. I'm gonna give you the 60 days.
okay.
Okay? Can we have another date?
June 22nd.
June 22nd, which will be on Monday at 11 a.m. Stand by. Can you provide notice? We're gonna give you notice of that right now.
Thank you.
Mr. Rakowski, anything else for the record?
It just looks like, at least the documentation here was that the transcript needs to be requested by Mr. Barron to the Secretary of State. And we don't deal with that aspect. We deal with it after it gets there. So I'm not sure what paperwork needs to be filed. I mean, we just don't have that. We just know that the letter here refers to that, indicating that they need notice of that hearing that the court is setting now, June 27th date from Mr. Barron, as well as the requirement for requesting the transcript. And then those documents should come to Mr. Barron, should come to us, should come to the court at that point, once those requests are made.
What letter are you referring to?
It's a letter dated February 13th from the Secretary of State.
That in the court file. It was only sent to you then.
It may have been just.
That's why I said there's been quite a bit of interaction back and forth from the state. And it just seems like, it's, yeah, on their time and nobody else's time, and whatever they say they got, and what they didn't, which is not, I've got a stack of papers back there that shows that I've done more than my share on everything.
Mr. Barron wants to talk to me about a separate matter, which I will do after the hearing. But we can print him a copy of what we received from the Secretary of State.
That would be great.
You can see. what we
That's
have.
much appreciated. Any problem with that, sir?
No, I'm actually asking the courts for help now because it's gotten to the point where, okay, when you make a mistake 30 years ago, it's one thing to pay for it. Okay, and do what you're expecting and everything else, but it's another thing, but when you try to go up there, it's always another roadblock that isn't yours.
Well, this court's not trying to block you from anything because we could dismiss the petition right now.
No, I understand.
We're not going
I'd have to
to.
go all the way through again.
Mr. Rakowski will get you a copy of that portion of the letter. You can contact him and hopefully in 60 days we can have it here.
I appreciate it. Thank you.
No problem. That'll be all. Thank you.
Thank you.
Alrighty, friends, that brings it to a close for today. Sort of. Tonight, In the Blind makes its triumphant return. You'll see me, you'll see Michael Groff, and it's a lot of fun. If you're not familiar with that show, just hang around until this show is done, and YouTube will automatically send you over there so you can hit the reminder button and join us tonight. That'll be at 7 p.m. Eastern, 4 p.m. Pacific, and we would love to have you over there. We're trying to grow that show. And the more of you who show up, the more that will help. So we hope we can see you there. It's not court that we do over there. We don't know what we're doing over there. We don't know what we're going to talk about until we go live and it's presented to us. That's what makes that show fun. So please do enjoy and join us. If you can't make that, or even if you can, come back here tomorrow, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member, and we will do this all over again. I hope you all had fun. I did. It is not only a pleasure, but a privilege to be with you every morning. So thank you so much. And until we see you next time, take care. God bless.